Groundbreaker. Okay.
Y'all may be seated.
Speech.
Do y'all have a new one?
Is this the new speech? Like the most recent speech? The interpreter? Okay. I know he'll change it, so. Can everyone hear us okay? Central? South?
Hey. Yes, ma'am, we can hear you.
Can we have an interpreter on?
Interpreter present, Your Honor. Elias Lopez, staff interpreter.
All right, Mr. Lopez, if it's okay with you, I'll just go through the speech, and then I'll let you do the whole thing in Spanish after I'm done.
Yes, Your Honor.
Good afternoon. This is your first appearance hearing. A first appearance hearing has 4 purposes and 4 purposes only. First, I'll advise you of the charges that have been filed against you. Second, I'll ask if you have an attorney representing you. If you've hired counsel and they're present, they'll speak on your behalf. If your attorney is not present, you'll have the option of proceeding forward with your hearing today or postponing it until tomorrow. If you postpone the hearing, it is your responsibility to contact your attorney to let them know that you will have court. No one else will do that for you. If you wish to move forward without your attorney present, we can do that. If you do not have an attorney, I'll ask if you can afford one. If so, we'll make note of that and move on. If not, and you qualify, I can provisionally appoint the Office of the Public Defender to represent you pending you filling out an application. You have a right to have your attorney present before and during any questioning. You also have a right to communicate with counsel, family, or friends, and if necessary, you'll be provided reasonable means to do so. Third, if there are any challenges to probable cause, I will address those. Finally, I'll review your bonds and/or other release conditions with you to determine if any changes are necessary. Be aware if this court places you on pretrial release today, regardless whether it is straight pretrial release or a condition of your bond, the conditions announced in court today go into effect immediately, meaning even while you remain in custody. So if you are given a no contact order, it is in effect immediately. Throughout this entire process, you have a constitutional right to remain silent. If you choose not to remain silent, anything you say can be used against you. Everything that is being said where I am located, as well as where all of you are located, is being recorded. There is an assistant state attorney present listening to everything that is being said. So do not say anything about the crime itself. Please keep these rights in mind as we go through this process. For those of you appearing virtually, if you are a non-lawyer, you are to keep your device on mute during the entire time you are present. In addition, you are not to turn your video feed on at any time. For the lawyers present, please keep your device muted. However, please do turn on your video so the court is aware you are present. For all of those present, pursuant to the rules of judicial administration, this meeting is not to be recorded in any form unless you are the press and you have prior permission from court administration. Mr. Lopez.
Yes, señora. Buenas tardes a todos. Esta es su audiencia de primera comparecencia. La audiencia de primera comparecencia tiene solamente 4 propósitos. Primero, le informaré sobre el cargo o los cargos que se han presentado en su contra. Segundo, le preguntaré si cuenta con un abogado que lo represente. Si ya usted ha contratado un abogado y este se encuentra presente, entonces será el abogado quien hable en su nombre. Si su abogado no está presente, usted tendrá la opción de proceder con su audiencia de hoy o posponerla hasta mañana. Si decide posponerla, será su responsabilidad contactar a su abogado para informarle que deberá presentarse a su audiencia. Nadie más hará esto por usted. Si usted desea continuar sin que su abogado esté presente, puede hacerlo. Si usted no tiene abogado, le preguntaré si tiene los medios para contratar uno. De ser así, tomaremos nota de esto y continuaremos. Si no tiene los medios y califica, el juez asignaría provisionalmente la oficina del defensor público para que le represente, sujeto a que usted llene una solicitud para estos servicios. Usted tiene derecho a que un abogado esté presente durante y antes de cualquier interrogatorio. Asimismo, tiene derecho a comunicarse con su abogado, familiares o amigos, y de ser necesario, se le proveerán los medios apropiados para hacerlo. Tercero, si hay alguna objeción en cuanto a motivo fundado, estas se abordarán inmediatamente. Finalmente, revisaré su fianza y otras condiciones de su puesta en libertad para determinar si es necesaria cualquier modificación. Tenga presente que si el juez lo pone hoy bajo libertad condicional, ya sea de manera directa o como condición de su fianza, las condiciones que se anuncien hoy en esta audiencia entrarán en efecto inmediatamente, aunque usted se encuentre aún bajo custodia. Entonces, si se le ordena no tener contacto con determinada persona, esta orden entrará en efecto inmediatamente. Durante todo este proceso, usted tiene el derecho constitucional de permanecer en silencio. Si usted decide no permanecer en silencio, todo lo que diga podrá ser usado en su contra. Todo lo que se diga donde yo me encuentro, así como también donde se encuentran ustedes, está siendo grabado. Hay un abogado de la Fiscalía presente escuchando todo lo que se dice, así que no diga nada usted sobre el delito en sí. Por favor, tenga presente estos derechos durante el transcurso de este procedimiento. Para quienes comparecen de manera virtual, si no son abogados, deben mantener su dispositivo en silencio durante todo el tiempo que estén presentes. Además, no deben activar su cámara en ningún momento. Para los abogados presentes, mantengan su dispositivo en silencio. Sin embargo, por favor activen su cámara para que el juez esté al tanto de su presencia. Para todos los presentes, conforme a las reglas de administración judicial, esta audiencia no podrá ser grabada en ninguna forma a menos que usted pertenezca a los medios y tenga autorización previa de la administración del tribunal. Gracias.
Thank you, Mr. Lopez. Can everyone please stand up and raise your right hands?
Todos de pie y levante la mano derecha.
Do you swear or affirm any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Juran que dirán la verdad y solamente la verdad. Digan que sí.
Thank you. Have a seat.
Gracias, pueden sentarse.
When your name is called, please step forward to the podium.
Cuando se llame su nombre, por favor pase al frente hasta el podio.
Mario Megan. Good afternoon, sir.
Buenas tardes, señor.
So you're charged with one count of driving while license suspended or revoked. That's a second-degree misdemeanor. It's punishable by up to 6 months in Polk County Jail.
Señor, usted está acusado con manejar con licencia suspendida o revocada. Este es un delito menor en segundo grado. Pena máxima, 6 meses de cárcel en la cárcel del condado.
Would you like an attorney appointed to represent you?
¿Quiere usted que se le asigne un abogado para que le represente?
No,
No.
Are you planning on hiring an attorney, sir?
¿Tiene usted pensado contratar un abogado, señor?
no he pensado.
No.
No,
Are you planning on representing yourself?
¿Tiene usted pensado representarse a sí mismo?
sí, porque yo tenía seguro.
Yes, because I had insurance.
Okay, this is a separate matter than whether or not you have insurance. This has to deal with your driver's license. I don't want you commenting on the facts of the case.
Bien, este es un caso aparte del seguro. Este tiene que ver con su licencia de conducir y no quiero que comente nada sobre los detalles del caso.
If you've never been to law school, I'm going to suggest that it might be very helpful to have someone represent you.
Si usted nunca ha ido a la escuela de abogacía, le sugiero que sería de bastante ayuda si usted tiene a alguien que le represente legalmente.
Ok,
Ok,
All right. Do you have any money saved in the bank?
¿usted tiene dinero ahorrado en el banco?
lo tengo aquí arriba, conmigo.
I have it with me.
Do you own any property?
¿Posee usted propiedades?
¿Cómo?
¿Posee usted propiedades?
No,
I'm going to provisionally appoint the Office of the Public Defender.
Voy a asignar provisionalmente la oficina del abogado público en su caso.
ok,
I'm going to set your bond at $250.
Voy a fijar su fianza en $250.
Your next court date is August 14th at 8:30.
Su próxima corte va a ser el 14 de agosto a las 8:30.
ok.
Ok.
Jessica Ramirez Hernandez.
Sandra Smith with the Public Defender's Office.
Good afternoon, Your Honor. Private counsel, Claudia Echeverry George, for the record, for Ms. Ramirez Hernandez.
Good afternoon, Ms. George.
Señora Claudia Echeverry George está representando a la señora Ramírez Hernández.
Your Honor, I believe she requires a Spanish interpreter.
Yes, we have one on the line.
Interpreter is present.
Your Honor, there is an order from Judge Flynn ordering her, and this is dated from today, and there was also one from yesterday. And the order is to revoke the warrant and to place her back, to release her and put her back on probation. And this was e-filed today at 12:41.
If it was
Señoría-
12:41, I certainly don't have it.
There is also one from
señoría,
yesterday.
I'm sorry.
Hold on, let Mr. Lopez interpret for your client.
Señoría, hay una orden del juez Flynn fechada con la fecha del día de hoy y también hay una del día de ayer para revocar su orden de detención y ponerla de regreso bajo libertad, regreso con su probatoria. Fue interpuesta electrónicamente el día de hoy. La jueza indica que si fue interpuesta el día de hoy, no la ha recibido todavía.
All right, it looks like, Madam Clerk found it. It looks like Mr. Matthews and Ms. Smith, I don't know if you've seen it.
Yes, ma'am. State acknowledges that the warrant was withdrawn prior to arrest.
La Fiscalía reconoce que esta orden fue retirada previamente al arresto.
I'd also respectfully note that there is a hold from ICE.
También hago notar respetuosamente de que hay una orden de detención por parte de ICE.
In the file, I'm showing an immigration detainer, an order to detain alien, and a Department of Homeland Security warrant for arrest of alien.
Y la orden que yo tengo de inmigración, el retén de inmigración, muestra que pertenece al Departamento de Seguridad Territorial para el arresto de Aileen.
And it appears that the identity of the accused is confirmed through biometric means.
Y al parecer la identidad de la acusada se ha confirmado a través de medios biométricos.
With regard to the Polk County matter, I believe the accused is entitled to release.
Con respecto al caso del condado Polk, creo que la acusada tiene derecho a liberación.
Ms. Echeverry, George, according to the order from Judge Flynn, I'm going to revoke the warrant and it looks like she is restored to probation.
Señora
ma'am.
Echeverry, George, conforme a la orden del juez Flynn, voy a revocar la orden de detención y a restaurar la probatoria.
Thank you, Your Honor.
Gracias, señoría. Gracias.
Mr. Lopez, those are the only two interpreter cases that I am aware of.
Announcement, Your Honor.
Let me just ask, Central, do you have any other interpreter cases that I am not aware of?
No, ma'am.
South County, any other interpreter cases that I'm not aware of?
No, ma'am, Judge, that's it. Don't have any.
Thank you. Thank you, Mr. Lopez.
Thank you, Judge.
She's released. She's back on probation. There's no more warrant. Okay. Howard Jordan?
Did you confirm that name, Judge?
I'm sorry?
Did you say Howard Jordan?
Yes, he's the juvenile.
Oh,
Oh, is
that's
it Jordan Howard?
Thank you.
Okay, sorry, it was written in comma, so I thought that was his first name.
I just wanted to be sure I was on the same case.
Yes.
Thank you.
Mr. Howard, can you hear me okay?
Yes, ma'am.
Are you his mom?
Yes.
Can you state your name for the record?
Bridget Jones.
Thank you. Mr. Howard, you are here on a direct information charging one count of burglary of a conveyance. That is a third-degree felony. It's punishable by up to 5 years in Florida State Prison. One count of criminal mischief, first-degree misdemeanor. That's punishable by up to a year in the jail. One count of grand theft. That is a third-degree felony, punishable by up to 5 years in Florida State Prison. One count grand theft of motor vehicle, a third-degree felony, punishable by up to 5 years in Florida State Prison. One count of burglary of a conveyance. That's a second-degree felony because they have added an enhancement of wearing a mask. That is punishable by up to 15 years in Florida State Prison. Count 6 is criminal mischief while wearing a mask. That is a first-degree misdemeanor, punishable by up to a year in jail. Count 7 is grand theft motor vehicle while wearing a mask. That is a second-degree felony, punishable by up to 15 years in Florida State Prison. One count of grand theft of a firearm. That is a third-degree felony, punishable by up to 5 years in Florida State Prison. One count of delinquent in possession of a firearm. That is a first-degree felony, punishable by life. 1 count of tampering with physical evidence, which is a 3rd-degree felony punishable up to 5 years in Florida State Prison. 1 count of resisting officers without violence. That is a 1st-degree misdemeanor punishable up to a year in jail. And 1 count of giving false identification to law enforcement, also a 1st-degree misdemeanor, and that is punishable up to a year in jail. Would you like an attorney appointed to represent you, sir?
Yes, no.
I'm going to provisionally appoint the Office of the Public Defender.
It has to be heard on the PBL too.
Yes.
A PBL is first-degree felony. The accused is not entitled to a bond under a PBL. State is requesting the court exercise its discretion and hold him no bond on that count. Thank you.
Sanderson, Public Defender's Office. My understanding, there's a difference between a PBL and a life felony. On a life felony, he is not entitled to bond for his appearances. However, on a punishable by life felony, it's discretionary with the court for his appearances, giving him a bond or not. So I would ask for a bond, noting that he is just 16 years old, and the charge of punishable by life felony is the delinquent in possession of a firearm, which is not, I wouldn't consider that a violent crime. It's just that he's had a firearm.
What's his history? Do you have it? Ms. Smith, have you reviewed his criminal history?
I have not, Your Honor. I don't look at juvenile records.
It is extensive.
Okay.
And when I say extensive, I mean 1, 2, 3, 4, 5, 6, 7 pages worth. All right, can you go back to the... All right, count 1, I'm setting his bond at $5,000. Count 2, $1,000. Count 3, $5,000. Count 4, $5,000. Count 5 will be $10,000. Count 6, $1,000. Count 7, $10,000. Count 8, $1,000. Count 9, he'll remain no bond. Count 10, $5,000. Count 11, $1,000, and count 12, $1,000. So your next court date is going to be August 18th at 8:15.
A request, a condition of bond be no contact with any named victim.
I will, if you do bond out, sir, which right now he doesn't have bonds on 1 count, you will be supervised by pretrial release. You won't leave the state of Florida without permission from the court. You'll wear a GPS monitor and be on house arrest conditions. You can leave the house for school, work, doctor's appointments, or church, or appointments with your attorney. You'll have no contact with the alleged victims.
Oh, there they go. We can't hear shit, though. Not him, though, but...
Okay, I'm not sure who's speaking, but
Which I can't see.
You'll stay at least 500 feet away from the event locations, the victims, their residences, place of employment. You'll not possess any weapons, firearms, ammunition, guns, knives. Yes. And that no contact starts now, sir. Thank you. Yes, you have a question? You're going to have to ask the deputy to unmute you.
You can hear me?
I can hear you now. Yes, sir.
On what charge would I have no bond on?
The possession of the firearm.
Okay.
All right. Your attorney will be out to speak with you. They can file the appropriate motion. ma'am, his next court date is August 18th. That'll be at 8:15.
Will I get a paper?
No, ma'am.
Oh, August 18th at
8:15.
okay, thank you.
Thank you.
Do I talk to anybody?
No, ma'am. Not today.
Okay.
You can stop down on the third floor is the public defender's office if you want to stop down there.
Okay.
And they might be able to talk to you about what happens next, okay?
Okay, thank you. Third floor.
Yes. South County, you ready?
Yes, Your Honor.
Do y'all want to call it or you want me to call it?
I can call it, Your Honor.
Go ahead.
The first one is Josiah Boyd.
I'll ask you on this one, Judge.
Mr. Boyd, good afternoon.
Good afternoon, Your Honor.
Sir, you're charged with 2 counts of improper exhibition of a firearm or a dangerous weapon. Each of those are first-degree misdemeanors, punishable by up to a year in jail. You're charged with 3 counts of domestic violence, aggravated battery on a pregnant victim. Each of those are second-degree felonies, punishable by up to 15 years in Florida State Prison. You're charged with 2 counts of child abuse with great bodily harm. Each of those are third-degree felonies, punishable by up to 5 years in Florida State Prison. You're charged with 3 counts of domestic violence, aggravated assault. Those are third-degree felonies, punishable by up to 5 years in Florida State Prison. 2 counts of use or display of a firearm during a felony. Each of those are second-degree felonies, punishable by up to 15 years. 3 counts of domestic violence, false imprisonment of a person. Each of those are third-degree felonies, punishable by up to 5 years. And 1 count of domestic violence battery, and that's a first-degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney appointed to represent you?
Yes, Your Honor.
All right. Do you own any property or have any substantial amount of money saved in the bank?
No, Your Honor.
I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit prior to court. I do find probable cause. Mr. Matthews?
Your Honor, with regard to the 3 third-degree felony counts of domestic violence, aggravated assault, the single misdemeanor count of domestic violence battery, the 2 counts of aggravated battery on a pregnant victim, 3 counts of that, 3 counts of domestic violence, false imprisonment, they're third-degree felonies, and the 2 F3 abuse of a child without great bodily harm. The state is filing a motion for pretrial detention. Providing a hard copy to appointed counsel. May I approach?
You may.
Presenting the motion to the court, I respectfully request the court review this motion for facial sufficiency, and if so found, hold the accused no bond on these counts, pending a hearing on this motion, which should be set next week on Monday at 1 p.m. on the A2 docket. Thank you.
The motion is facially sufficient. I will hold him no bond pending a hearing on the motion for pretrial detention. Are there any counts left that you are not seeking pretrial detention on, Mr. Matthews, that I need to set bond?
Yes, ma'am. There are 2 counts of display of a firearm during a felony. Those are not qualifying offenses under 907-041. And 2 counts of improper exhibition of a firearm. Those are first-degree misdemeanors. Those are not qualifying offenses under 907-041. I would respectfully request either pretrial release, supervision, or condition of bond, including no contact with the named victim.
As to those F2s,
I think there are counts 1, 2, 3, and 4 on the docket at least.
yeah, as to those 2 F2s, I'm going to set his bond at $15,000 each count. And then the improper exhibition, I'll set at $1,000 each count. If he does bond out, he will be supervised by pretrial release. You won't leave the state without permission. You'll have a GPS monitor. You'll be on house arrest conditions. You cannot return to the address where the victim resides. You'll have no contact with the victim, intentionally or unintentionally. No contact means no contact. No calling, texting, emailing, Snapchatting, Whatever other apps are out there, no contact, you understand?
Yes, Your Honor.
If you need to return to the address one time to collect your belongings, you may do that with law enforcement one time within 48 hours of your release. Do not go there without law enforcement. If you go without law enforcement, it will constitute a violation of your pretrial release. Do you understand?
Yes, Your Honor.
You will not use or possess any weapons, firearms, guns, ammunition, or knives. You can leave the home under GPS monitoring for court, attorney appointments, doctor's appointments, or work.
Yes, Your Honor.
Your next court date is September 1st at 8:15.
Thank you.
Next, Your Honor, we have Jake Crawford, however, he bonded.
All right, thank you.
Next, we have Kyle Davis.
Sanderson Public Defender's Office. This is a bring back from yesterday. Our office was appointed to the case. These are the 3 probable cause challenges that Judge Gunner qualified on yesterday. I have since received a new report from the state. I would note that on the possession of psilocybin, or however you say that, that charge is not even in the new police report, so I would ask for ROR on that one charge. On the other 2 charges, I no longer have a probable cause challenge of the sale of cocaine within 1,000 feet of a church and the possession of alprazolam with intent to sell based on the new affidavit.
Mr. Matthews, when I reviewed the affidavit, I did not see any mention of possession of psilocybin. You agree he should be ROR'd on that count?
I believe, my recollection is it reads that there is no field test available for psilocybin. So that is the only information I have to present.
All right, based on my review of the amended affidavit.
Yes, Your Honor, it's not even mentioned as one of the charges in the amended affidavit.
Yeah, it's not. I'm going to set count 1, on what's left over, sale of cocaine within 1,000 feet of a church or school.
Actually, it's possession of cocaine with intent to sell.
Yeah, it looks like it's different on the paperwork that the clerk has.
Yesterday it was
I think
sale.
yesterday it was sale, right?
Yeah, today they changed it to possession of cocaine with intent to sell on an amended affidavit, and that was a probable challenge I believe the judge had yesterday. Is he was charged with sale of cocaine, not possession of cocaine with intent to sell, but they did correct it on their new amended affidavit.
So as to I will find probable cause for possession of cocaine with intent to sell within 1,000 feet of a church, and I will set bond on that count at 10,000. Count 2, the possession of psilocybin, I'm going to ROR him, and the possession of alprazolam with intent to sell, I'm going to set his bond at 5,000 and find probable cause as to that count. 5,000. Thank you, sir.
David Dean.
Sanderson Public Defender's Office. This is a bring back case of Pinellas County bring back. He was back at first appearances on July 22nd, and again, this is a 7-day review hearing today, so to see if the other county was going to come get him, Pinellas County. They did not come get him in a week, and as I always do, I always ask for ROR at this point, really soon as I'm reconnaissance, since they've had a whole entire week to come get him, and they chose not to.
Mr. Matthews, you want to be heard?
As the court, I'm sure is aware, I do not have any additional information to give. These matters do not flow through the state attorney's office here, so it would not be unusual for me not to know. I know that classifications does try to notify me if they know there's an issue so that I can present that to the court. And I do not have any additional information to provide in that regard. I do not have access to the teletype system in any capacity.
Didn't the warrant have a bond set with it?
Yes, Your Honor, he does.
$1,000.13, which is an odd amount, but I think that's what it was set at.
Yes, Your Honor, I don't know why in the docket it says no bond, but he did have a bond. He's been unable to post the $1,000.13 in the last week to get out of jail.
Since it's only been 7 days at this point, I'm not gonna ROR him yet because he's got a bond of $1,000.13 according to the out-of-county warrant. I don't like to adjust other judges' warrants because I don't know anything, and I'll note that this is for failing to appear. So, had he appeared, he probably wouldn't be in this mess. But we will set him for another 7 days and make sure that they've been notified and see what happens in a week.
I would just ask that, they be notified if they haven't already.
If they haven't been notified, I'll make sure that they are notified.
Thank you.
Thank you, sir.
For Landry Edward,
What was the last name?
Edward?
First name Carl Landry.
last name is Edward.
Oh, I see it now.
Good afternoon, sir.
Good afternoon.
Sir, you're here on a capias that was issued for pretrial release, and the judge has asked that you be held no bond and be brought before the judge within 5 days. Do you already have counsel on that case, sir?
Yes, ma'am.
All right. Who's the judge in that?
Hill, Judge Hill, F6.
Can we set him in the next 5 days?
Yes, ma'am, it's on Monday the 3rd at 8:30.
All right, sir, you're gonna see Judge Hill on Monday
10-4.
You know what time Monday?
at 8:30? 8:30, Ms. Smith.
Thank you.
All right, good luck, sir.
Trevin Harris.
Afternoon, sir.
Vaughn Harris.
So you're charged with domestic felony battery with a prior conviction. It's a second-degree felony. It's a aggravated battery, bodily harm, second-degree felony, punished by up to 15 years in Florida State Prison. Would you like an attorney appointed to represent you?
Yes, please, Your Honor.
Do you have any substantial savings in the bank, or do you own any property?
No, ma'am, Your Honor.
It was admitted to domestic felony battery prior conviction.
Yes, it was actually lowered. I just wanted to.
So it's an F3.
It's now an F3.
All right. I will provisionally appoint the Office of the Public Defender. I am finding probable cause of that offense. I reviewed the affidavit prior to court. I'm going to set your bond at $5,000. If you bond, you're going to be supervised by pretrial release. You won't leave the state of Florida without permission from the court. You'll have no contact directly or indirectly with the alleged victim. You'll stay at least 500 feet away from her home, her place of employment, school, church. No contact means no contact. No calling, texting, emailing, tweeting, Snapchatting, whatever other apps are out there that I don't know about. No asking other people to contact her for you. If you need to return to the residence to get your belongings, you can do that one time within 48 hours of your release with law enforcement. Do not go to the house without law enforcement. If you go without law enforcement, it will be a violation of your pretrial. You will not possess any weapons, guns, ammunition, knives. You understand what I mean when I say no contact and that it starts now?
Yes, Your Honor. I have a question, if I may ask.
Sure.
So if I was to be bonded out, would I be able to leave the state of Florida to like a resident of a family member in case?
Sir, the first thing that I told you is you can't leave the state of Florida without permission from the court. So that means that you will have to have your attorney file a motion.
Okay, yes, sir.
All right? Your next court date is September 1st at 8:15.
Yes, Your Honor. Thank you.
Landon Mathis.
Good afternoon, sir.
Good afternoon, ma'am.
You're here on a violation of probation, sir. You're going to be held no bond until you see the judge. Would you like an attorney appointed?
Yes, ma'am.
Do you have any substantial savings or do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. You're going to see the judge on August 24th at 8:30.
Yes, ma'am.
Good luck, sir.
Thank you.
Britton McCullough.
Good afternoon, sir.
Good afternoon, Your Honor. How are you doing?
Good. You're charged with 1 count of petty theft. It's a first-degree misdemeanor. It's punishable up to a year in jail. Would you like an attorney appointed to represent you?
Yes, Your Honor.
All right. Do you have any money saved in the bank or do you own any property?
No, Your Honor, I do not.
I'll provisionally appoint the Office of the Public Defender. I've reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000. Your next court date's August 14th at 8:30.
The next one is Alexander Romero.
Your Honor.
Good afternoon, sir.
Good afternoon, Your Honor.
Sir, you're charged with 1 count of domestic violence battery by strangulation. It's the third. Can I see that correctly? Yeah, that's a third-degree felony. It's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed to represent you? South County, we had to mute everybody. Okay, thank you. You would like an attorney?
Yes, please.
Do you have any substantial savings or do you own any property?
No, I own a property in my house.
All right, I'll provisionally appoint the Office of the Public Defender. This came in as a warrant, so probable cause is already found. I'm going to set your bond at $5,000. If you bond out, you're going to be supervised by pretrial release. You won't leave the state without permission from the court. You'll check in with them once a week. You won't use or possess any weapons, guns, firearms, ammunition, knives. You'll have no contact directly or indirectly with the alleged victim. You'll stay at least 500 feet away from their home, their place of business, school, vehicle, etc. No contact means no contact. No calling, texting, Snapchatting, WhatsApp, emailing, whatever other electronic means there are, and that starts now. No contact, you understand?
I do, Honor.
All right, if you need to return to the home to get your belongings, you can do so one time within 48 hours with law enforcement. Do not go to the home without law enforcement. If you go to the home without law enforcement, it will violate your pretrial. Do you understand?
Yes, ma'am.
All right, your next court date is September 1st at 8:15.
Thank you.
Michael Stevenson.
Senator Smith with the Public Defender's Office. I do want to weigh the reading of his first-degree felony charge, and it appears his violation of probation is an interstate BOP, which is a fugitive case. He could be appointed to. I'm not sure which state that is from.
I'll ask to be heard as well.
Mr. Stevenson, did they tell you what you're charged with, sir?
They said second degree
You don't
or
have to
something.
say. Your attorney, the public defender asked me to waive reading. I just want to make sure somebody notified you.
Yes, ma'am.
All right, would you like an attorney appointed?
Yes, ma'am.
Do you have any savings or do you own any property?
Now I get a disability check.
All right, I'll provisionally appoint the Office of the Public Defender. Mr. Matthews?
Presuming a finding of probable cause, Your Honor, the state is filing a motion for pretrial detention on the unnamed count. Providing a hard copy to appointed counsel, may I approach?
You may.
Providing the motion to the court, I would request the court review that motion for facial sufficiency, and if so found, hold the accused no bond pending a hearing on that motion, be set next Monday at 1 o'clock on the A2 docket. Thank you.
I have reviewed the probable cause affidavit. I do find probable cause. The motion for pretrial detention is facially sufficient. I will hold him no bond, and he will be set on August 3rd at 1 p.m. for that hearing. What state is his?
North Carolina, Cumberland County, Fayetteville.
It just has to be appointed on that also.
I'll also appoint the public defender's office on that. All right, good luck, sir.
Thank you.
Next, Your Honor, we have Jason Tondi. However, we were informed he was being combative.
Your Honor, Sanderson Public Defender's Office, I know this is his first time, but we already represent him on several matters. I feel comfortable waiving his appearance and just being asked to be appointed on this case unless the court wants to continue it one more time.
I'm fine doing that.
Thank you. I just asked to be appointed on his new charges.
I'll provisionally appoint the Office of the Public Defender. Did you want me to review it for bonds?
Yes, sir, I would just ask for bonds on the charges.
I did review the affidavit. I do find probable cause. As to the resisting without charges, his bond will be set at $1,000. As to the resisting with, his bond will be set at $5,000, and as to the bat Leo, his bond will be set at $5,000.
Next, Your Honor, we have Mark Kidwell.
Afternoon, sir. You're charged with knowingly driving while your license is suspended or revoked. That is a second-degree misdemeanor. It's punishable up to 6 months in jail. Would you like an attorney appointed?
No, ma'am.
You gonna hire one?
I'm not really sure what I'm gonna do. I don't normally get in trouble.
Okay. Do you have the funds to hire one?
I own my own house.
Okay. If you're unable to hire one, or if you change your mind, just let the judge at your next court appearance know, and they can try to appoint one for you, okay?
Okay.
I have reviewed the affidavit. I do find probable cause. I'm gonna set your bond at $250, and your next court date is August 14th at 8:30.
Yes, ma'am. Thank you.
And lastly, Judge, we have Muhammad Williams.
Good afternoon, sir.
Good
You're
afternoon.
charged with one count of resisting an officer without violence. It's a first-degree misdemeanor, and it's punishable up to a year in jail. 2 counts.
Yes, ma'am. I was,
The affidavit has 2. Oh, he's got a warrant, right? Okay, let's talk about the resisting without first. It's punishable up to a year in jail. Would you like an attorney appointed?
no, ma'am. He said he wasn't going to give me the resistant arrest because I was behind the couch trying to find my shoes.
No, hold up, stop talking. Did you hear the whole speech that we have to
Oh, ma'am.
beginning?
Okay.
Everything you say can be recorded, all that? Did you hear it?
Yes, ma'am.
There is literally a prosecutor sitting in the room with me, taking down notes on everything you're saying. It's not a good idea, okay? Do you want a lawyer? Because
Yes,
you have
ma'am.
a charge of resisting without.
Yes, ma'am.
Do you have any money saved in the bank, or do you own
No,
any
ma'am.
property?
No,
I'll
ma'am.
provisionally appoint the Office of Public Defender. I have reviewed the affidavit. I do find probable cause. His bond on that count will be $1,000. Let's talk about your DRD warrant. You've got a warrant for child support. Looks like you owed a purge amount of $100 by June. So I'm gonna leave your purge amount set at $100 on the DRD. Your next court date is August 14th, 8:30.
Your Honor, that's all we have for South County.
Thank you, South County. Y'all have a good day.
You too.
All right, Central, I'm ready when y'all are.
Kelsey Albritton.
Good afternoon, ma'am.
Good afternoon. I am so sorry about something.
Ma'am, you're charged with 1 count of resisting an officer without violence. 1 count, that's a first-degree misdemeanor. 1 count of possession of drug paraphernalia, first-degree misdemeanor. 1 count of trespass, a first-degree misdemeanor. Each of those is punishable up to 1 year in jail, and 1 count of possession of methamphetamine, a third-degree felony, and that's punishable up to 5 years in Florida State Prison.
It's crazy. I know my film at all.
Ma'am, did you hear the part where I said don't talk about the facts of the case?
Okay.
That was for everybody. Would you like an attorney appointed to represent you?
Yeah.
Do you have any money saved in the bank? Do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit. I do find probable cause as to the
So you
resistance.
find probable cause, like you to the roundabout of all of you find probable cause.
Ma'am, I'm not discussing it with you. Your attorney can answer any questions that you have.
For the meth and every, I'm saying find probable cause.
I found probable cause.
Okay.
Count one,
Okay.
her bond will be set at 1,000. Count two, 1,000. Count
This
three,
is right
5,000.
on the
Count four, 1,000. It's my
It's crazy,
understanding that
this is
she
dumb
is
as
on
fuck.
probation, Mr. Matthews, at
I'm saying I'm in real O'Hara.
3814.
Judge, I looked up that case and I found that it was no bill by SAO intake, so I think that that is not an open case.
All right, thank you. Your next court date is going to be July, what is it?
Hey, look, it's nasty over here. Like where y'all have me at, y'all need to talk. Y'all need to get it together because this place is disgusting. This place is disgusting. I mean, you can't even. I can charge you for renter's lease law.
Don't make it harder. You're gonna pick up extra charges.
What's the next?
Caleb. Caleb Beatty.
Oh my goodness.
Good afternoon, sir.
I'm not, is he talking to me?
Are you Ms. Beatty?
I'm a female.
What is your name?
Caleb Bade.
Bade. My apologies. We don't know how to say everyone's name. Just correct us when we get it wrong. You're charged with one count of resisting an officer without violence.
What? I can't hear what? I'm sorry, there was noise here.
You are charged with one count of resisting an officer without violence. That is a
No,
first-degree
I didn't resist. I didn't resist. I just, I mean, you trying to, I just say, listen, I don't agree, listen, I don't agree. I didn't resist. I didn't try to run off or anything like that, so, no. Step over there.
Ms. Smith, I am going to provisionally appoint the Office of the Public Defender. I'm going to set her bonds at $1,000 on the resisting and $250 on the trespass. I did find probable cause.
Simone Bell.
I'm sorry, ma'am, what's your name?
Simone Bell. Yes.
All right, Ms. Bell, you're charged with one count of knowingly driving while your license is suspended or revoked. That is a second-degree misdemeanor. It's punishable by up to 6 months in jail. One count of petty theft. That's also a second-degree misdemeanor, punishable by up to 6 months in jail. And one count of aggravated battery with a deadly weapon. And that's a second-degree felony, and it's punishable by up to 15 years in Florida State Prison. Would you like an attorney appointed to represent you? Oh, Central, you're muted. We had to mute everybody.
Yes, ma'am.
Okay, do you have any money saved in the bank? Do you own any property?
No.
I'll provisionally appoint the Office of the Public Defender. As to the M2s, your bond is going to be set at $250 on each count. As to the aggravated battery, your bond is going to be set at $10,000. If you do bond, you're going to be supervised by pretrial release. You won't leave the state of Florida without permission. You won't drive without a valid driver's license. You'll have no contact with the alleged victim directly or indirectly. You'll stay at least 500 feet away from the event location, their residence, school, place of employment, etc. You won't use, possess, or carry any firearms, guns, weapons, ammunition, or knives. Your next court date is August 14th on the misdemeanors at 8:30.
Okay.
Good luck.
Thank you. Brenda Cottrell.
All right, Ms. Cottrell, you're charged with one count of possession of drug paraphernalia, first-degree misdemeanor, punishable by up to 1 year in jail, and one count of possession of methamphetamine, a third-degree felony, and that's punishable by up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property, or do you have any money saved in the bank?
No, ma'am.
I'm going to provisionally appoint the Office of the Public Defender. I did review the affidavit. I do find probable cause. I'm gonna set your bond at 1,000 on the para and 5,000 on the methamphetamine, and your next court date is September 1st at 8:15.
Yes, ma'am.
Good luck.
Wesley Ann Crocco?
Crocco.
Crocco?
Anderson Defender's Office. As of course, probably aware, she and her husband are both charged with domestic battery on each other. My understanding is they lived at the same address. In the vision comment, she indicated they both wanted to have contact with each other. I was going to ask if they could both be straight pretrial released and have no violent contact with each other.
At this time, the state would object to that, Judge.
To the straight pretrial release and or the contact, or just the straight pretrial release?
Or both of them, Judge, based on the allegations in the affidavit for each of the two defendants. One, I think a bond would be appropriate, and until further proceedings, the state's position is no contact would be advisable. Thank you.
All right, Ms. Crocco, you're charged with one count of domestic violence battery on a person aged 65 years of age or older. It's a third-degree felony. It's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes.
Do you have any money saved in the bank, or do you own any property?
I have a small amount saved and I'm 50% owner in our home.
Is the home paid for?
No.
Okay. They'll have you fill out an application. I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit. I do find probable cause. I think bonds are appropriate based on the circumstances. You want to have contact with your husband, ma'am?
Yes, I have no problem with it.
You're not in fear of him if both of you
No.
were to return to your home?
No.
Is Mr. Crocco there? I know we're doing females right now, but can I have him come forward so that I can just deal with them at the same time?
Jamie, step on the phone.
Sir, do you want to have contact with your wife?
Yes, Your Honor.
Are you concerned for your safety if the two of you return to your home together?
No, Your Honor.
All right, you can have a seat until we call your case. Thank you.
Thank you.
All right, at this point, I'm going to order no violent contact. I'm going to set your bond at $5,000, ma'am. If you do bond, you are going to be supervised by pretrial. You'll check in with them. You won't possess any weapons, guns, firearms, ammunition, knives. You'll have no violent contact with your husband. When I say no violent contact, I want you to understand what I mean. I mean no screaming, yelling, throwing things, raising your voice in such a way that he may fear that violence is about to take place. You'll keep your hands to yourself. Do you understand?
Yes.
Yeah.
Your next court date is September 1st at 8:15.
Thank you.
Jamie Disney?
Ms. Disney, you're charged with one count of possession of drug paraphernalia, a first-degree misdemeanor, that's punishable up to a year in jail, and one count of possession of methamphetamine, that's a third-degree felony, it's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed to represent you?
Yes.
Do you have any money saved in the bank, or do you own any property?
No.
I'll provisionally appoint the Office of the Public Defender. Mr. Matthews, it looks as though she may have an open case, if you could verify that for me.
She does CF 266679 and on release for possession of meth and paraphernalia.
She's out on bond on that case?
Yes, ma'am.
All right. I have reviewed the affidavit. I do find probable cause. In this case, I'm going to set your bond at $1,000 for the para and $5,000 for the methamphetamine. As to CF 266679, I am revoking your bond, and you'll be held no bond pursuant to Parker v. State. Your next court date is September 1st at 8:15.
Cynthia Green?
Good afternoon, Ms. Green.
Good afternoon, Your Honor.
Charged with one count of possession of drug paraphernalia, a first-degree misdemeanor, that's punishable up to a year in jail. One count of possession of cocaine, that's a third-degree felony, it's punishable up to 5 years in Florida State Prison. And one count of trafficking in fentanyl, 28 grams or more, that is a first-degree felony, and it's punishable up to 30 years in Florida State Prison. Would you like an attorney appointed to represent you?
Yes, ma'am.
Do you own any property or do you have any money saved in the bank?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit. I do find probable cause. Mr. Matthews?
Your Honor, with regards to the count of trafficking in fentanyl, that is an enumerated dangerous offense in 907041. State is filing a motion for pretrial detention and providing a hard copy to appointed counsel. May I approach?
You may.
Respectfully request the court review this motion for facial sufficiency, and if so found, hold the accused no bond, pending a hearing on this motion to be set next Monday at 1 o'clock on the A2 docket. Thank you.
As to count one, I'm going to set your bond at 1,000. As to count two, your bond will be set at 5,000. As to the trafficking, I'm going to hold you no bond pending a motion for pretrial detention that will be heard on Monday, August 3rd at 1 p.m. Thank you, ma'am.
Candace Harper.
Good afternoon, ma'am. You're charged with one count of driving while license suspended or revoked. Third or subsequent DWLSR, it's a third-degree felony and it's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes.
Do you own any property or have any money saved in the bank?
No.
I'll provisionally appoint the Office of the Public Defender. I previously reviewed the affidavit. I do find probable cause. I'm going to set your bond at $5,000. Your next court date is September 1st.
Lindsay Harris.
Good afternoon, Ms. Harris. You're charged with one count of possession of methamphetamine, a third-degree felony. That's punishable up to 5 years in Florida State Prison. One count of possession of drug paraphernalia, a first-degree misdemeanor. That's punishable up to a year in jail. One count of keeping a nuisance or structure, a third-degree felony, punishable up to 5 years in Florida State Prison. And one count of possession of cannabis over 20 grams, also a third-degree felony, punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes.
Do you own any property or have any substantial savings?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. I'm setting your bond at $5,000 each count on the felonies and $1,000 on the misdemeanor. Your next court date is September 1st at 8:15.
Thank you.
Diane Henley.
Good afternoon, ma'am. You're here on violations of probation. Would you like an attorney appointed?
Yes, ma'am.
Do you have any money saved in the bank or do you own any property?
Nope.
I'll provisionally appoint the Office of the Public Defender. You're going to be held no bond until you see the judge in violations of probation, and that will happen on August 24th at 8:30.
Robin Holland.
Good afternoon, ma'am. You're charged with one count of possession of drug paraphernalia, a first-degree misdemeanor, punishable up to 1 year in jail, and one count of possession of methamphetamine, a third-degree felony, and that's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, please.
Do you own any property or have any substantial savings?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. I'm setting your bond at $1,000 as to count one and $5,000 as to count two. Your next court date is September 1st at 8:15.
All right, thank you.
Maria Jimenez Perez.
Spanish, please. Spanish.
Judge, now she's asking for Spanish.
You don't speak English, ma'am?
No.
All right, pass her to the end, and we'll get an interpreter back at the end.
Have a seat. Connie Polk.
Good afternoon, ma'am.
Good afternoon.
You're here on a violation of probation.
Yes, ma'am.
That was filed by your probation officer for failing to submit to a drug test. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved in the bank?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. You're going to remain no bond until you see the judge, and that'll be on August 28th.
Thank you.
24th, sorry, August 24th.
Okay.
Cassidy Lewis.
Good afternoon, Ms. Lewis.
Good afternoon.
You're charged with violations of probation for a failed drug test. Would you like an attorney appointed?
Yes.
Do you have any money saved in the bank, or do you own any property?
No.
I'll provisionally appoint the Office of the Public Defender. You're going to be held no bond until you see the judge on the violation. That'll be on August 24th.
Donna Lewis.
Afternoon, Ms. Lewis.
Good afternoon.
You're charged with 1 count of trespass. That's a first-degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney appointed?
Yes.
Do you own any property or have any money saved?
No.
I'll provisionally appoint the Office of the Public Defender. I did review the affidavit. I do find probable cause. I'm gonna ROR her. She's gonna be ROR'd. Good luck, ma'am. Your next court date is August 14th.
Barbara Lott.
Afternoon, Ms. Lott. You're charged with 1 count of possession of cannabis, less than 20 grams. It's a first-degree misdemeanor, and 1 count of possession of drug paraphernalia, also a first-degree misdemeanor. Each of those is punishable by up to a year in jail. Would you like an attorney appointed?
Yeah. Yeah. Yes.
Okay, do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. Your bond's going to be set at $1,000 on each count. Your next court date's August 14th at 8:30.
Carrie McNew.
Yep.
Good afternoon, ma'am. You're here on an out-of-county warrant. Looks like for failing to appear on a charge over in Sumter County.
Yes, ma'am. My bondsman told me the wrong date.
Okay, you're gonna have to take that up with your bondsman. I can't do anything about that. I got a warrant from Sumter that I can't change, so.
Yes, ma'am.
They've requested that you be held no bond and that we let them know when we've got you, so we will let them know that you are here so they can come pick you up, and we will set you for first appearance again on August 5th at 1 p.m. to make sure they've come to get you.
All right, thank you.
Jamie Mott.
Good afternoon.
Hello.
You're here charged with violations of probation and 1 count of domestic violence battery, which is a first-degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney appointed?
Yes.
Do you own any property or have any money saved?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit. I do find probable cause. As to the domestic violence battery, I'll set your bond at $1,000. You're going to be no bond as to the violations of probation. If you do bond, you're going to be supervised by pretrial. You'll check in with them. You won't leave the state without permission from the court. You won't possess or carry any firearms, guns, weapons, ammunitions, or knives, and you'll have no contact with the alleged victim directly or indirectly. That means calling, texting, emailing, Snapchatting, having somebody else reach out for you. If you need to return to the residence to get your belongings, you can do that one time with law enforcement within 48 hours of your release. Do not go without law enforcement. It will violate you. You understand?
I do understand that, but I do have a question.
What's your question?
Because my probation address is that address. So what do I do?
You're gonna have to talk to your probation officer and update your address with probation, because you can't
Okay.
return to that address, okay?
Okay.
All right, good luck.
When's my next court date for the BOP?
August 24th.
Haley Neal.
Good afternoon. You're here on a violation of probation out of Orange County, it looks like.
Yes, ma'am.
Is that a no bond? We will notify that Orange County, you're on probation in Orange County? We're here.
My probation originally was out of Volusia County, but I transferred it to Orange County. So I guess Orange County.
See where I mean, it says Orange, but I don't see where they got that from.
As far as like my family's been able to look up, they said that they couldn't find any kind of like paperwork. They called Orange County and everything, and Volusia County, and both of them have no violation paperwork at all.
This was unrelated.
This is just the affidavit.
It looks like they have filed an affidavit for violation in Orange County.
Okay.
Do you have pending charges here?
No, I just completed my US date was yesterday. I just completed my sentence.
Okay, so we just need, Ms. Smith, we just need to let Orange County know that she's here and then put her on the 8-5 first appearance docket to see if they've come to get her?
Yes, ma'am.
All right, so we'll let them know that you're here, and
Okay.
I'll set you back on the first appearance docket here on August 5th to see if they've come to pick you up.
Okay, thank you.
Sarah Tapia.
Skipped an O will be, I guess. Are we in Tapia?
What's your name?
Sarah Tapia.
All right, Ms. Tapia, you're here on a violation of probation. Would you like an attorney appointed?
Yes.
Do you have any money saved, or do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. You're going to be held no bond until you see the judge. That'll be on August 24th at 8:30.
Tamika Thomas.
Good afternoon, ma'am. You're here charged with violations of probation. Would you like an attorney appointed?
I already have one.
Okay, sounds like you've got a public defender.
Yes, ma'am.
Clerk's office. Her attorney, Pam Hoffman, came to see me this morning and wanted to ask if she could get a 5-day hearing on this particular case in front of Judge Grodd.
Can you put her on Judge Grodd's docket in 5 days?
Can I call this JA?
Sure. We'll see if we can get Judge Grodd's JA on the line. Ms. Hoffman probably expected Judge Grodd to be here today.
Yes, Your Honor.
I am not him.
When would be a good day to set a 5-day hearing? He's on vacation next week, she said.
When's his first day back that we can?
When is the next available day? It's not next week.
is August 10th.
He's on vacation, August 10th at what time?
Thank you. At 8:30.
Thank you, and I'll let Ms. Hoffman know.
All right.
Thank you.
If you might call. Ms. Thomas, they're going to get you on, in front of Judge Grode. His very next availability is August 10th at 8:30, and that's when you're set.
Yes, ma'am. Thank you.
Was the name announced?
Volunis? Is that your last
Yes.
name, Volunis?
Yes, Your Honor.
You're charged with 1 count of domestic violence battery. That's a first-degree misdemeanor. It's punishable by up to 1 year in Polk County Jail. Would you like an attorney appointed?
Yes, Your Honor.
Do you have any property, or do you have any money saved in the bank?
No, Your Honor.
I'll provisionally appoint the Office of the Public Defender. I did review the affidavit. I do find probable cause. I'm going to set your bond at $1,000. If you bond, you're going to be supervised by pretrial release. You'll check in with them. You won't leave the state without permission from the court. You won't use or possess any weapons, knives, firearms, guns, ammunition. You'll stay at least 500 feet away from the alleged victim's residence, place of business, school, church. You'll have no contact directly or indirectly with the alleged victim. That means no calling, texting, emailing, reaching out through third parties. That starts today, you understand?
Yes, Your Honor.
If you need to return to the residence to get your belongings, you can do so one time within 48 hours of your release with law enforcement. Don't go without law enforcement. It will violate your conditions, you understand?
Yes, Your Honor.
All right, your next court date is going to be August 14th. Good luck.
Thank you. I just have one quick question. The person I spoke to earlier on the phone did recommend me for early, like, pretrial release. Was that denied?
I'm not sure who you spoke to, so
Okay.
I'm not sure what you mean by early pretrial release.
I don't really know the correct, like legal, like legality, like the term, but they said something about possibly like just getting out early and then having a temporary injunction issued because it was a family member.
Well, there is a no contact order that is now in
Right.
effect, because I just announced that, but I did
Right.
give you a bond, so as soon as you bond, you can be released.
Okay, perfect. Thank you.
You're welcome.
Jennifer Water. They skipped me. My name is Sadie Ogilvy, and I need a chance to speak. Have a seat.
Ma'am, sit down until your case is called. Ms. Waters, you're charged with 1 count of possession of drug paraphernalia, a first-degree misdemeanor. It's punishable up to a year in jail, and 1 count of possession of methamphetamine, a third-degree felony, punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes.
Do you have any money saved, or do you own any property?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. I'm setting your bond at $1,000 on the paraphernalia and $5,000 on the methamphetamine, and your next court date is September 1st.
All right. Okay, thank you.
Khadijah Wright.
Good afternoon, Ms. Wright. You're charged with 1 count of petty theft. It's a second-degree misdemeanor, and it's punishable up to 6 months in jail. Would you like an attorney appointed?
Yes.
Do you have any money saved in the bank, or do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit. I do find probable cause. I'm setting your bond at $250. Your next court date is August 14th.
Sadie Ogilvy.
Ms. Ogilvy, you're here on 2 different matters. One is a violation of probation out of, I believe, Orange County. And one is a charge of misuse of 911 system. That is a first-degree misdemeanor, and it's punishable up to 1 year in Polk County Jail. Would you like an attorney appointed to represent you?
Yes.
That's a that's a false allegation.
I don't need commentary. I just need you to answer my questions. Do you own any property or do you have any money saved in the bank?
No.
I'll provisionally appoint the office of the public defender.
My ex is connected with these corrupt cops. It's connected with Epstein. These police are trying to kill me. I am a whistleblower for Epstein and criminal sex trafficking. These police are corrupt and they're trying to kill me. God has protected me. I need a lawyer and I need to get out of this jail. I am surrounded by corrupted cops. They're trying to kill me. I have been followed by cops for a year and a half. They're trying to take my money because I am a whistleblower. I've been followed. There are many victims out there. There are many victims. This is a federal government. These cops are corrupted and they're trying to poison me. They're trying to kill me. They're connected with Sean Combs and Epstein.
What the what? What the hell did I just walk into? Did she just say what I think I heard? Sheen Gators. Hey, what's up to everybody listening to this live court? Highly appreciate Taser! Taser, officer! Taser! Get the K9! If you will.
Good afternoon, Your Honor.
Good afternoon, sir. You're here charged with violations of probation. Would you like an attorney appointed?
Yes, Your Honor.
Do you own any property or have any money saved?
No, Your Honor.
I'll provisionally appoint the office of the public defender. You're going to be held no bond until you see the judge. Your next court date is August 24th.
May I add something, Your Honor? I've been incarcerated in prison since February 2022. They just picked me up yesterday.
Okay. Good luck to you. Is this Mr. Armstead?
Yes, ma'am.
Good afternoon, sir.
Good afternoon, Your Honor.
You're charged with one count of operating a motor vehicle without a registration. That's a second-degree misdemeanor. One count of attaching an unassigned tag, a second-degree misdemeanor. And one count of driving without a license or driving with a license suspended or revoked. That's also a second-degree misdemeanor. Each of those is punishable by up to 6 months in jail. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved in the bank?
No, ma'am.
I'll provisionally appoint the office of the public defender. I have reviewed the affidavit. I do find probable cause. As to those counts, I'm setting his bond at $250 each count. Mr. Matthews, does he have an open felony case in 26 CF 0429?
Yes, ma'am. Charging fleeing to elude, driving with a suspended license, and other driving charges.
As to 26 CF 0429, I am revoking your bonds and you will be held no bond pursuant to Parker v. State. Your next court date is going to be August 14th at 8:30.
Russell Hansberry.
Good afternoon, sir.
Good afternoon.
Sir, you're here charged with failing to give information at a crash, which is a second-degree misdemeanor, DUI, first-degree misdemeanor, DUI involving property damage, first-degree misdemeanor, and refusal to submit to a blood alcohol test, a second-degree misdemeanor. Second-degree misdemeanors are punishable by up to 6 months in jail, and the first-degree misdemeanors are punishable by up to a year. Would you like an attorney appointed?
Yes, ma'am.
Do you have any money saved in the bank?
No,
Or
ma'am.
do you own any property?
No, ma'am.
I'll provisionally appoint the office of the public defender. How many is that?
Judge was telling me more with the dates for something in Texas. There's a few that say
Different dates, there's only 4. All right. I've reviewed the affidavit and I do find probable cause. I'm not sure, Ms. Smith, if you've been able to review his criminal history. It appears that he has multiple DUIs out of the state of Texas. And I can't tell exactly how many, but at least on separate dates, it looks like there's at least 4 prior driving under the influence out of the state of Texas. Therefore, I am finding that it is appropriate to elevate his bond today. And for the DUI counts, his bond will be set at $5,000 on each count. The remaining counts will be set at $1,000 each. If you bond out, you will be supervised by pretrial, sir. You'll check in with them. You won't leave the state of Florida without permission from the court. You won't drive without a valid driver's license. You won't frequent any bar or lounge. You won't consume any alcohol. You won't go to any restaurant where or any place where the main source of income is alcohol. You'll be subject to random urine or breath tests for alcohol, and you're going to have a curfew from 8 p.m. to 6 a.m. That may be modified for work purposes if you show proof of employment and your hours to pretrial. Your next court date is going to be August 14th.
All right.
Helen Barnhill.
Mr. Barnhill, you're here on a violation of probation. Would you like an attorney appointed?
Yes, ma'am.
Do you have any money saved in the bank, or do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. You're going to be held no bond until you see the judge, and that's going to be on August 24th.
Charles Batt.
Sanderson Public Defender's Office. And I just wanted to clarify that on the docket it shows 2 BOPs for 2 different case numbers. I would point out that those are not BOP cases. As this is just a violation of GPS monitor, because on April 20th, 2026, he pled to 270 days. Balance to be set on GPS. Not be appointed to the cases because they're not violation of probation matters. It's just, he was sentenced to GPS monitoring and violated GPS monitoring, so my understanding is he just does a balance on jail time is how that works, but we can't be appointed to those cases because they're.
Sir, they have you listed as violations of probation, but it looks like, Mr. Marcus, is he just serving the remainder of a sentence, or is he actually on a term of probation?
I do not know. I
It does look like he's on a new term, right? So, Ms. Smith, the snap out for 23 CF 7237, dated January 15th, 2025. Looks like he pled to a new term of 24 months on count 1.
Well, at some point though, on April 20th of 2026, it looks like not revoked. Because usually they revoke it and
24 CF, which case?
I mean, not CF, I'm looking at their CT cases and then these. Hold on a second.
The 26 CT 2273 and 25 MM 7809. The 24
Are you showing you probation on those?
May I approach, Judge?
You may. Yeah, it looks like those are included on the.
That's what I thought, it's not a probation.
This is on the MM case. I'm presenting is just what I show in stacked.
Straight time. And
That's
that's
the
for
last
May
entry.
of 2026. Okay, so then he's just going to serve his time straight and be released.
Thank you for the relief. Again, if I can give you a few more minutes, I'll keep digging.
Yeah, can you pull up what you have on that felony case? Because the last snap out from January that the clerk pulled up for me, it's January 15th, 2025.
I do not have a felony case.
24 CF 3647.
Okay, I was just looking at the stuff on the docket. I don't even know about the felony. Hold on.
Yeah.
Same with me, Judge.
I was just looking at the misdemeanor mark.
It looks like there was also 23 CF 7237.
Yeah, that wasn't on the docket.
Sorry, could you give me was there a CF 243647?
Yes, sir.
And that's for Bennett Barnhill.
Yes, Cameron Barnhill.
Are we not on defendant back?
Yes, that's the wrong defendant. This is Bass.
Barnhill. Thank you, because he's the person.
Yep, that's the wrong thing.
I'm sorry. I was saying that on the 2 misdemeanor cases,
Do you have a felony case in this?
Nope.
I don't think he ever got probation.
Because I show it's a CT case and an MM case.
I'll look him up by ID number, at least in statute.
What's the latest one? This one. All right, looks like on June 23rd, 2026, restored a GPS house arrest with prior conditions. And then the snap out that you showed me, Mr. Matthews, what was the date on that?
My apologies, Judge, my computer's.
Your Honor, I had a violation on my GPS. The charges got no billed. I was reinstated on my GPS. I'm monitoring.
Sir, hold on.
Was May 15th, 2026.
So the one from June looks like he was reinstated, right? Yeah. So the snap out from June looks like he was reinstated to house arrest.
I guess I'm confused. When did you're saying he actually pled to probation on this case at some point in time?
Not to this one. When he fled the first time, it was 270 days, but then the balance to be served GPS house arrest.
What about on that?
Same motion to modify probation.
What about that MM case? Is that the one that he was on probation for originally? It's gotta be.
No. Was never on probation.
Yeah, I don't know if probation's listening or not, but it was my opinion on these cases that
Well, there's a motion to modify probation filed in the court file, so somebody was on probation.
Okay,
Wasn't. I was never on probation.
Sir, please stop talking and let us handle it, okay? If I have questions, I'm gonna let you know.
That was actually a motion to modify community control is what I'm looking at. And it says the actual motion, if you actually read, not the label that somebody gave it.
Go back to the
It says,
original.
if you read the motion to
judgment.
modify community control, it says they want to modify the condition of community control concerning house arrest, that he was sentenced to 270 days county jail with the balance to be served in GPS house arrest on April 20th. This is what I've been saying all along. And he was trying to get that modified, but that's not really, that wasn't probation though.
Right? No,
That's mislabeled, it should have said motion to
Okay,
modify.
but here's the thing, Ms. Smith, his very first judgment and sentence in that case, in that MM case,
Okay.
on 12/10/2025, is for 12 months of probation. So he was on probation at some point.
On the MM case?
Yeah, MM 257809.
Just one moment.
A violation of an injunction.
Then in April, his probation was revoked. He was sentenced to 270 days.
His probation was revoked.
Balance to be served on GPS house arrest.
Okay, so he's no longer on probation then as of April 20th.
Then on June 26th, he was restored to GPS house arrest with prior conditions.
Right, Your Honor, but once his probation is revoked, it's revoked. On April 20th, it was revoked. So he was just dealing with the house arrest at that point, as for his sentence for the probation violation.
I understand that. At this point, it sounds like he just needs to serve the remainder of his sentence straight.
That's what I thought from the very beginning, Your Honor. I thought that's what it what was clear.
That's what
So
she
I don't
said.
even know that do we want to keep his court date on August 3rd or November 1st?
But we just can't be appointed to that because it's not really a violation of probation is what I meant.
All right, we'll keep the court date if anything changes, but it looks like right now, sir, you just got to serve out the remainder of your house arrest straight time. I don't know how much time you got left. He's giving me no bond.
Yeah.
Now, the new charges, does he have new charges? Those aren't new, right? That's the original charges?
We can be appointed to those.
Okay. The new charges, sir, you've got 1 count of possession of drug paraphernalia, a first-degree misdemeanor. It's punishable up to a year in jail. 1 count of possession of cannabis, over 20 grams, third-degree felony. 1 count of keeping a structure, third-degree felony. Those are punishable up to 5 years. 1 count of possession of methamphetamine with intent to sell, a second-degree felony, punishable up to 15 years. Would you like an attorney appointed on those charges?
Yes.
Do you have any money saved in the bank or do you own any property?
No.
I'll provisionally appoint the Office of the Public Defender. I've reviewed that affidavit. I do find probable cause. As to those charges, on the M1, your bond's going to be set at $1,000. On the F3s, your bond's going to be set at $5,000, and on the F2, your bond is going to be set at $10,000. On the M2, and that's it, I think. Right. So once you serve your time, you'll be able to bond. I think.
Iris Boone.
Yes, ma'am.
Good afternoon, sir. You're charged with 1 count of resisting an officer without violence, a first-degree misdemeanor. Punishable up to a year in jail, and 1 count of driving while license suspended or revoked, a second-degree misdemeanor, punishable up to 6 months in jail. Would you like an attorney appointed?
Yes.
Do you own any property or have any money saved in the bank?
Yes.
You do? How much money you got saved in the bank?
Probably about, a couple of thousand.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000 on the resisting and $250 on the driving charge. Mr. Matthews, does he have an open felony case in 26 CF 6222?
Yes, in 6222, and that was carrying a concealed firearm unlawfully and drug-related charges.
In 26 CF 6222, I'm going to revoke his bond and hold him no bond pursuant to Parker v. State. Your next court date's August 14th.
August 14th, okay.
Terrence Bryan.
Good afternoon, sir. You're charged with 1 count of possession of drug paraphernalia, a first-degree misdemeanor, punishable up to a year in jail, and 1 count of possession of cannabis resin. It's a third-degree felony. It's punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
Do you have any money saved in the bank, or do you own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit. I do find probable cause. Your bond's going to be set at $1,000 on the misdemeanor and $5,000 on the felony, and your next court date is September 1st.
Okay.
Michael Bergen. Borgorn.
Good afternoon, sir. You're charged with a violation of probation. Would you like an attorney? I'm sorry?
Yes, ma'am.
Okay, do you own any property or have any money saved?
I do not.
I provisionally appoint the Office of the Public Defender. You're going to be held no bond. You'll see the judge on August 24th.
William Butler.
Your Honor, Sanderson Public Defender's Office. I would like to point out this is a bring back. He had a first appearances on back on July 22nd. The other county, St. Lucie, hasn't come get him in a week, so I'd ask for him to release him as own recognizance.
States received notice of classifications, pickup is imminent.
I would ask for another reset of the status hearing.
All right, we'll set him for next Friday. Or, I mean, August 5th. Is that Friday? What is that?
It's a Wednesday.
All right, August 5th. We'll set him. It sounds like they're on their way to get you any day, sir.
I was given a day and time, but I've been instructed not to put that on the record.
Yes.
Thank you.
James Carter.
Good afternoon, sir.
Good afternoon.
You're charged with violation of your pretrial release. It's a first-degree misdemeanor. It's punishable up to a year in jail. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I've reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000 in this case. Mr. Matthews, he's on pretrial release in 26 MM 5277. Is that correct?
Yes, ma'am, that's for domestic violence, assault, and I would request in the instant case that a condition of pretrial release be imposed, the condition being no contact with the named victim, because the state is going to request that the release in MM 26-5277 be revoked and he be held no bond in that case. But if there's not a new order of no contact, then there won't be an order of no contact.
I am going to revoke his bond in 26 MM 5277 since the alleged victims in both cases are the same. I will reinstate pretrial release conditions, the same pretrial release conditions he had in 26 MM 5277 will go into effect in the new case. Sir, you're going to see that your next court date is August 14th.
Colby Christian.
Good afternoon, sir. You're charged
Good
with
afternoon.
possession of drug paraphernalia, a first-degree misdemeanor, and one count of possession of methamphetamine, a third-degree felony. The misdemeanor is punishable up to a year in jail, and the felony is punishable up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
Do you have any money saved in the bank or own any property?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. I'm setting your bond at $1,000 on the para and $5,000 on the methamphetamine. Your next court date is September 1st.
Thank you.
Michael Clofo.
Good afternoon, sir. You're charged with one count of domestic violence battery. It's a first-degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney appointed?
Yes.
Do you have any money saved in the bank or do you own any property?
Yes, both.
How much do you have saved?
Hmm.
Enough to
over
hire a lawyer?
Pardon me?
Enough to hire an attorney?
Yes.
Okay, I'm going to let you hire an attorney. If you're unable to hire an attorney, you can let the judge know at your next court date, okay?
I can. May I ask you a question first?
Let me get through what I need to get through and then yes, okay?
Yes, ma'am.
I have reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000. As to the pretrial release conditions, I'm going to allow you the same pretrial conditions that I ordered your wife. No violent contact between you and your wife. When I say no violent contact, that means no screaming, yelling, throwing things, anything that makes the other person fearful that violence may occur. You understand?
Yes, ma'am.
Okay, what's your question?
Ma'am, I have chronic lymphocytic leukemia, which is a blood cancer, and I've been over 30 hours without my medication. I've been to the infirmary here. The medication is not available for a number of days to here. I was wondering if it's possible if I could be released so I can get my medication.
I've set your bond. I've set your bond at $1,000, so you can bond out.
Okay, so this is my first time here. I have no idea what that means.
You're going to have to either hire an attorney or pay the $1,000 to bond out, or you can go through a bondsman.
Okay, can I pay the $1,000 personally, or?
You can, yes. If you have that, you can pay it, and they can release you.
Okay.
Okay?
Thank you.
All right, your next court date is August 14th.
Thank you.
Jose Antonio Cruz.
Good afternoon, sir.
Good afternoon, ma'am.
You're here on a violation of probation out of what looks like Sumter County.
Yes, ma'am.
They've asked that you be held no bond, so we're gonna let them know that you're here, and I'm gonna set you on, next week's first appearance at 1 o'clock to see if they've picked you up, okay?
Yes, ma'am.
All right, good luck.
What date is that for next week?
August 5th.
All right, thank you.
Willis Deloach.
Good afternoon, sir. You're charged with 1 count of possession of drug paraphernalia, a first-degree misdemeanor, 1 count of possession of cocaine, a third-degree felony punishable by up to 5 years, and 1 count of driving while license suspended or revoked. That's a first-degree misdemeanor, and each of those is punishable by up to a year in jail. Would you like an attorney appointed?
Yes.
You own any property or have any money saved?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. I'm setting your bond at $1,000 on the misdemeanors and $5,000 on the felony. Does he have an open case in 26 CF 7484?
Because I didn't have him on my list. Could you
It
give me
may
that
not,
number
it may
again?
not.
I'm sorry?
It may not be him.
Could you give me the case number again?
Okay, no, that's the new case number, never mind.
Oh, very well.
Sir, your next court date is September 1st.
So I have a bond?
You do,
Okay.
1,000 on the misdemeanors and 5,000 on the, felony.
Thank you.
Robert Gray.
Sanderson Public Defender's Office, I have qualified challenges.
All right, sir, you're charged with 1 count of possession of paraphernalia, a first-degree misdemeanor, 1 count of possession of cannabis, a first-degree misdemeanor. Each of those is punishable by up to a year in jail. Would you like an attorney appointed?
Yes, please.
Do you have any property or money saved in the bank?
No, ma'am, I do not.
I'll provisionally appoint the Office of the Public Defender.
Sanderson Public Defender's Office, Your Honor. I'm challenging both counts. It just says it revealed a presumptive positive for THC, but it doesn't say the THC content, which usually they put it's over 0.3% or 1%. It doesn't say anything like that and differentiate it from being hemp.
Mr. Matthews, any response?
Aside from what the defendant himself is alleged to have said, I only have what's in the affidavit. The court is not inclined to find PCF. Will be requesting 24 hours to perfect. Thank you.
Ms. Smith, do you want me to set a bond in the event that, since the state is asking for 24 hours, that he's not just sitting?
Well, yes, from my understanding, he right now has presumptive bonds of 1,000 each. I would just ask that those remain there,
Yes.
in case he wants to bond out before tomorrow.
I do find probable cause as to the paraphernalia. I'll roll the cannabis over for 24 hours. He does have a bond of $1,000 in the event that the state is able to make probable cause. If not, he'll be ROR tomorrow on that count.
I just point out and reiterate that my challenge is on both because you have to have it to be legal.
I understand your argument.
Okay.
I like her. I like her.
Gerald Trigger.
Good afternoon, sir. You're charged with trespass. It's a first-degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney?
Yes, ma'am.
Do you have any property or any money saved in the bank?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I
Okay.
reviewed the affidavit. I do find probable cause. I'm gonna straight pretrial release him. He just needs to call in once a week to pretrial. Your next court date is August 14th. Or are you changing?
Marcus Edwards.
9-3, sorry. I'm sorry, who did you call?
Marcus Edwards.
Thank you. Mr. Edwards, you're charged with 1 count of possession of cannabis, a first-degree misdemeanor, 1 count of resisting an officer without violence, a first-degree misdemeanor, and 1 count of possession of drug paraphernalia, a first-degree misdemeanor. Each of those is punishable by up to a year in jail. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I did review the affidavit prior to court. I do find probable cause. I'm setting your bond at $1,000 on each count. Your next court date is August 14th.
Okay. Thank you.
Dominic Figueroa.
Good afternoon, sir. You're here charged with trespass. It's a first-degree misdemeanor and it's punishable up to a year in jail. Would you like an attorney?
Yes, please.
Do you have any money saved in the bank or own any
No.
property? I'll
No.
provisionally I'll appoint the office of the public defender. I've reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000. Your next court date is August 14th.
Darian Gardner.
Dariana. Dariana.
Mr.
Yes, ma'am.
Gardner, you're charged with one count of domestic violence battery with a prior conviction. It's a third-degree felony. It's punishable by up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved in the bank?
No, ma'am.
I'll provisionally appoint the office of the public defender. I've reviewed the affidavit prior to court. I do find probable cause. Setting your bond at $5,000. If you bond, you're going to be supervised by pretrial. You're going to check in with them. You won't leave the state without permission. You won't possess or use any weapons, guns, firearms, ammunition, or knives. You'll have no contact directly or indirectly with the alleged victim. That means no calling, texting, emailing, reaching out through third parties. That starts right now. You'll stay at least 500 feet away from her residence, place of employment, school, etc. You do not reside together, is that correct?
No, ma'am, but she do got some of my belongings.
You can take that up in civil court. You do not need to have any contact with her. Do you understand?
Yes, ma'am.
All right, your next court date is September 1st.
Appreciate you.
Brantley Gardner.
Good afternoon, Your Honor.
Good afternoon.
There's the one qualified challenge in this case.
Sir, you're charged with two counts of use or possession of ID of another person, third-degree felonies, 2 counts of petty theft, $100 to $750, third-degree felonies, 1 count of an illegal use of a two-way communication device, third-degree felony, 2 counts of unlawful possession of personal ID, third-degree felonies. Each of those third-degree felonies is punishable up to 5 years in Florida State Prison. You're charged with 2 counts of burglary of conveyance. Each of those are second-degree felonies, punishable up to 15 years in Florida State Prison. And 1 count of theft or retaining a credit card of another, a first-degree misdemeanor, punishable up to a year in jail. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved in the bank?
No, ma'am.
I'll provisionally appoint the office of the public defender. Ms. Smith, which count are you challenging?
One of the 2 counts of unlawful possession of personal ID of 5 or more. Because in and of itself, that's a charge that you can really only charge one of, because there's more than, you can't charge it twice. It doesn't make sense.
Mr. Matthews?
I spoke with defense counsel prior to court, and I would acknowledge that based on the affidavit and the facts before the court at this time, that charge is, the way that it functions is broad enough to cover all of the qualifying cards, at least as far as I can tell at this point. So I would not object to defense counsel's challenge.
All right, I'm gonna ROR him and find no PC as to one of those 2 counts, Ms. Smith.
Thank you.
The remainder of the F3s, his bonds are gonna be set at 5,000 on each count. The M1 is gonna be set at 1,000 and the F2s are gonna be set at 10,000 each. If he bonds, he's gonna be supervised by pretrial. You won't leave the state of Florida without permission. You'll have a curfew from 10 p.m. to 6 a.m. That can be modified for work purposes if you show that you, if you provide your schedule to pretrial. You'll have no contact with any of the alleged victims or any of the event locations. Your next court date is September 1st at 8:15.
Yes, ma'am. Can I ask you one question real quick?
Go ahead.
So what's like the total bond amount?
I don't have the total. 5, 10, 15, 20, 25, 35, 45, 50, 55, 56,000.
Yes, ma'am. Thank you.
Darren Blanton.
Mr. Clerk, Defender's Office, I do have 1 probable cause challenge.
Yes. I'm sorry, who is this? Mr. Glanton?
Darren Blanton.
Mr. Glanton, you're charged with 1 count of possession of cannabis within 1,000 feet of a church. That's a second degree felony and punishable up to 15 years. 1 count of keeping a structure, a third degree felony. 1 count of possession of cannabis with intent to sell, third degree felony. 1 count of possession of cannabis over 20 grams, third degree felony. Each of those are punishable up to 5 years. And 1 count of possession of paraphernalia, first degree misdemeanor, punishable by up to 1 year. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. Ms. Smith, which count do you have a challenge on?
The possession of cannabis with intent to sell within 1,000 feet of a church. I'm challenging that as they didn't put down how many feet the incident was away from the church. They didn't specify the actual amount of feet. I would point out, my understanding, he's also charged with possession of cannabis with intent to sell, which would be subsumed in that higher charge. I'm not challenging the possession of cannabis with intent to sell, and it's my position he can't be charged with both of those charges anyway, but I am challenging the one within 1,000 feet of a church since it wasn't specified.
Mr. Matthews?
Your Honor, in reviewing the affidavit, I did not see the language regarding the church for a distance that was named. I saw that in the narrative, the case filing agent wrote that as a charge as well as on the cover, the face page. I would acknowledge that the possessed contraband is the same for both of those charges. Because I did not see really any information regarding the church, I have to presume that that was either added by mistake or something else. So I would ask the court to find probable cause for the possession with intent to sell. And if further information comes to light, of course, the charging may change with our intake.
Okay, I'm going to ROR him on count 1, and his bonds will be set at $5,000 on the other felonies and $1,000 on the misdemeanor.
$2,000, what we did.
So you're charged with 1 count of possession of drug paraphernalia, a first degree misdemeanor. It's punishable by up to a year in jail. Would you like an attorney?
Yes.
Sorry. Do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the Office of the Public Defender. I have reviewed the affidavit. I do find probable cause. I'm going to set your bond at $1,000. Your next court date is August 14th.
Thank you.
Willie Harvin.
Good afternoon, sir. You're charged with driving while license suspended or revoked. A first degree felony. It's punishable by up to a year in jail. Would you like an attorney appointed?
Yes.
Do you have any money saved?
No.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit. I do find probable cause. Your bond's going to be set at $1,000. Your next court date is August 14th.
It has to be heard regarding.
Oh, he's got an open case, right?
Yeah,
Two open cases.
Yes, ma'am.
25 CF
7707.
and 8401.
Yes, ma'am.
Are those similar in charge?
One is racketeering and other related type charges. The other is, trying to read my own handwriting. Oh, yeah, shooting into a conveyance, shooting in a residential area. State will request that he be revoked.
His bonds in those two cases are going to be revoked. He's going to be held no bond in 25 CF 8401 and 25 CF 7707 pursuant to Parker v. State.
Thank you.
Cedric Houston.
Good afternoon, Your Honor.
Good afternoon, sir. You're charged with violation of probation and one count of driving under the influence, and one count of driving under the influence, the blood alcohol level 0.15 or higher. Would you like an attorney appointed?
Yes, ma'am.
You own any property?
No,
Have any
ma'am.
money saved? I'll provisionally
No, ma'am.
appoint the office of the public defender.
I ask you a question, Your Honor?
Quickly.
Yes, ma'am. This is my first violation. It's misdemeanor. And I was trying to get a bond. If I don't, I'm gonna lose my job.
I can't give you a bond on a violation, sir.
Yes, ma'am. No problem.
But I have reviewed the affidavit and I do find probable cause. I'm setting your bond in the new case at $1,000. If you bond, you'll be supervised by pretrial. You won't drive without a valid driver's license. You won't leave the state without permission. You won't enter any alcohol or any bars or lounges. You won't use any alcohol. You'll be subject to random testing, either urine or breath at your expense, and you'll have a curfew from 10 p.m. to 6 a.m. that can be modified for work.
Yes, ma'am.
Your next court date is August 24th.
Thank you.
James Humphrey?
Yes, ma'am. Good afternoon, Your Honor.
Good afternoon, sir. You're charged with a violation of probation. Would you like an attorney?
Yes, ma'am.
Do you own any property or have any money saved?
No, ma'am.
All right, I'll provisionally appoint the office of the public defender. You're going to be held no bond. You'll see the judge on August 24th.
Yes, ma'am. Thank you.
Devontae Isaac?
Good afternoon, sir. You're charged with violation of probation. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved?
No, ma'am.
I'll provisionally appoint the office of the public defender. You're going to be held no bond. You're going to see the judge on August 24th.
Thank you.
Nigel Knight?
Sanderson, Public Defender's Office. I have a stipulation, I believe, with the state on this case. It doesn't change the degree, it's still third-degree felony, but there is actually probable cause not for habitual driving, but driving while suspended with two prior GSR convictions. That's what the affidavit suggests. It's still a third-degree felony, it's just not habitual.
State agrees.
All right, sir, would you like an attorney appointed? It's a third-degree felony. It's punishable up to 5 years.
I already got an attorney.
Okay. I'm going to set your bond at $5,000. Your next court date is September 1st.
Oh, wait, I got a court date tomorrow. How you gonna pick me up in jail?
Maldonado? Daniel Maldonado?
I'll ask you heard on this one.
So you're charged with one count of knowingly driving while license suspended oh, I'm sorry. This is a different Maldonado. You're charging one count of trafficking in fentanyl over 4 grams. That is a first-degree felony. It's punishable by 30 years in Florida State Prison. Would you like an attorney?
I already have an attorney,
Who is it?
Brittany Burke.
Okay, are you comfortable going forward without your attorney here?
No, I actually would like him here. I thought he was gonna be here by now.
I don't believe we've had anyone announce their presence. I'm happy to set you for tomorrow if you would like.
Well, the thing is, I do have the charge that I got was changed because of a previous charge that I caught in February 14th.
Sir, I just need to know if you want me to go forward without your attorney or if you want me to reset you for tomorrow so that you can notify your attorney to be here.
Yeah, just set me up for tomorrow.
Great, we'll roll into tomorrow. This Cesar Maldonado?
Sanderson, Public Defender's Office. I believe you
Josiah Martinez. Josiah Martinez.
Okay.
Josiah Martinez.
I got it.
I'm sorry, I thought we were calling Maldonado.
What happened to Cesar Maldonado?
He bonded.
You bonded. All right. Mr. Martinez, you're charged with one count of possession of paraphernalia, first-degree misdemeanor, one count of possession of cannabis resin, a third-degree felony, punishable by up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
Do you own any property or have any money saved?
Yes, ma'am.
Enough to hire an attorney?
Yes, ma'am.
All right, if you're unable to hire an attorney, you can let the judge know at your next court date. I've reviewed the affidavit. I do find probable cause. Did you want to be heard, Ms. Smith? Is that what you said?
But that was on the other one that bonded that I didn't realize had bonded.
I do find probable cause. Your bond's going to be set at 1,000 on the misdemeanor and 5,000 on the felony, and your next court date is September 1st.
Yes, ma'am.
Damon Mackey.
Good afternoon, sir. You're charged with, you're here on a failure to appear KPS. You failed to appear for pretrial conference. The judge has set your bond in the amount of $7,500.
Okay.
Your next court date is September 2nd.
Oh, the defender's already appointed.
I believe so.
Yes.
They can't do back, yeah.
Sir, you're here on a failure to appear KPS. It appears that you did not appear for arraignment. The judge has set your bond in the amount of $2,000 in each count. Do you already have a lawyer in that case?
No, ma'am. I was in prison when that court date was set.
Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. Your next court date's August 6th.
Yes, ma'am.
Which bond?
So you're charged with 1 count of domestic violence battery, a first-degree misdemeanor punishable by up to a year in jail, and 1 count of false imprisonment, a third-degree felony punishable by up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, Your Honor.
I'll provisionally appoint the Office of the Public Defender.
I see that the victim allegedly sent a chat just now.
I've reviewed the affidavit. I do find probable cause. I'm going to set your bond at 1,000 on the misdemeanor and 5,000 on the felony. If you bond, you're going to be supervised by pretrial. You won't leave the state of Florida without permission. You won't use or possess any weapons, firearms, ammunitions, guns. You'll have no contact with the alleged victim directly or indirectly. That starts now. No contact means no contact. You'll stay at least 500 feet away from their home, school, place of employment, vehicle. If you need to return to the residence to get your belongings, you can do so one time with law enforcement within 48 hours of your release. Don't go without law enforcement. It will violate you.
Ma'am, I just have one question. I don't mean to hold you up.
Go ahead, quickly.
We do reside with each other and have a 3-year-old son. I was going to ask about... Never mind. I just seen a message she sent. It's okay.
Okay. Good luck. Your next
Thank
court
you so
date
much.
is September 1st.
Thank you, Your Honor. Have a good day.
Councilman Owen.
Mr. Owens, you're charged with 1 count of possession of paraphernalia, first-degree misdemeanor, punishable by up to a year in jail, and 1 count of possession of methamphetamine, a third-degree felony, is punishable by up to 5 years. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. Your bond's going to be set at $1,000 on the misdemeanor and $5,000 on the felony. Your next court date is September 1st.
There we go.
George Roden.
Jermaine Roden.
Mr. Roden, you're charged with 1 count of driving under the influence, a first-degree misdemeanor. It's punishable by up to a year, and 1 count of refusing to submit to a breath test.
Vera Barker.
And that's also that's a second-degree misdemeanor, punishable by up to 6 months. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court, and I do find probable cause. Your bond's going to be set at $1,000 on each count. If you bond, you're going to be supervised by pretrial. You'll check in with them. You won't drive without a valid driver's license. You won't go to any bar or lounge. You won't possess or use any alcohol. You'll be subject to random breath tests or urine tests. And you'll have a curfew from 10 p.m. to 6 a.m. That can be modified for work purposes. Your next court date is August 14th.
Angel Rivera Vargas.
Good afternoon, sir. You're charged with violation of probation. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. You're going to be held no bond. You'll see the judge on August 24th.
Christopher Rivers.
Mr. Rivers, you're charged with 1 count of possession of an open container, a second-degree misdemeanor punishable by up to 6 months in jail, 1 count of possession of drug paraphernalia, a first-degree misdemeanor punishable by up to a year in jail, and 1 count of possession of cocaine, a third-degree felony punishable by up to 5 years in Florida State Prison. Would you like an attorney appointed?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. I did review the affidavit prior to court. I do find probable cause. I'm setting your bond at $250 on count 1, $1,000 on count 2, and $5,000 on count 3. Your next court date is September 1st.
Thank you.
Christopher Scott.
Sanderson, Public Defender's Office. I do have a stipulation with the state regarding one of the counts that they're on the simple misdemeanor charge of possession of cannabis, that there is no probable cause on that charge. He should be released on his own recognizance on that one charge since it's subsumed in the other charges.
All right. Sir, would you like an attorney appointed to represent you?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. Pursuant to the agreement, I'm going to set your bond at $5,000 on the 2 counts and ROR you on the 3rd count. Your next court date is September 1st.
She was talking to me?
Yes.
Oh, I didn't hear my charges.
Possession with intent to sell or deliver, a third-degree felony. Sale of cannabis, a third-degree felony. Possession of cannabis, misdemeanor, first-degree misdemeanor.
Your Honor, the officer said I only had one charge.
I'm not discussing what the officer said. Those are your charges. I've set your bonds.
I got 3 charges.
Jason Shannon.
Sanderson Public Defender's Office has to be appointed. We represent him on several cases. He's been found incompetent to proceed on several cases. I would ask for ROR. I would point out in case number 2025 CF 000214 VA, he was found to be incompetent to proceed due to intellectual disability and or autism, finding his competency is non-restorable and releasing him on his own recognizance. That was in a felony case, and Judge Pinkett signed that order on April 16, 2026, which is not too far away. We do represent him on a lot of other misdemeanor cases.
Any objection to that, Mr. Matthews?
Yes, Your Honor. For the new case, state objects.
I'm going to find there is probable cause as to the possession of cannabis and possession of drug paraphernalia based on the recent finding of Judge Pinkett that he is non-restorable. I'm going to ROR him on these 2 counts.
Okay, thank you, ma'am.
Shaw.
Sorry. Yes, appoint PD. Is this Mr. Shaw?
Yes, ma'am.
So you're charged with 1 count of operating while driver's license suspended or revoked, a first-degree misdemeanor.
Yes, ma'am.
It's a second-degree misdemeanor. It's punishable by up to 6 months. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. I did review the affidavit. I'm finding probable cause, and I'm setting your bond at $250.
Yes,
Your
ma'am.
next court date is August 14th.
Thank you.
Desmond Simmons.
Mr. Simmons, you're here on a violation of probation. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the office of the public defender. You're going to be held no bond, and you'll see the judge on August 3rd.
August 3rd? Okay.
Yes.
Dr. Will Potter.
Sir, you're charged with 1 count of possession of cannabis, first-degree misdemeanor, punishable by up to 1 year in Polk County Jail. 1 count of use or display of a firearm during a felony. That's a second-degree felony, punishable by up to 15 years in Florida State Prison. 1 count of possession of oxycodone, a third-degree felony, punishable by up to 5 years, and 1 count of possession of paraphernalia, first-degree misdemeanor. Would you like an attorney appointed?
Yes, Your Honor.
I'll provisionally appoint the office of the public defender. I reviewed the affidavit. I do find probable cause. Your bonds are gonna be set at 5,000 on the F3, 1,000 on each misdemeanor, and 10,000 on the second degree misdemeanor. Your next court date is September 1st.
Thank you, Your Honor.
What's your name,
Good
sir?
evening, Ryan Taylor.
Mr. Taylor, you're here on a warrant out of Broward County. Looks like you got a purge amount of $538.88. We'll let them know that you are here, and I'll put you on the docket for first appearance August 5th at 1 to see if they've come to get you.
Yes, ma'am. Ma'am, do you can you see when that purge was?
I have no information. All I know is that's what it says. I mean, I don't know when it was entered. I just know that it's still, looks like this one's from 7/29. So today.
Yeah, 'cause I'm currently still working and they taking money out my check, ma'am. So
Sir,
I don't.
I have no idea. Sorry.
And it's in Broward County. That's
Looks
for Broward.
like it's in Broward. Are you Mr. Thomas?
Yes, ma'am.
You're charged with 1 count of possession of drug paraphernalia, a first degree misdemeanor. It's punishable up to a year in jail. 1 count of possession of methamphetamine, a third degree felony, punishable up to 5 years. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause. Your bond is set at 1,000 on the misdemeanor and 5,000 on the felony. Your next court date is September 1st.
Javier Torres.
Good afternoon, Your Honor.
Mr. Torres, good afternoon. You're charged with driving while license suspended or revoked. It's a second degree misdemeanor, punishable up to 6 months in jail. Would you like an attorney?
Yes, ma'am.
I'll provisionally appoint the Office of the Public Defender. I reviewed the affidavit prior to court. I do find probable cause, and I'm going to set your bond at $250. Your next court date is August 14th.
Thank you, Your Honor.
Daniel Torres.
Mr. Torres, good afternoon. You're charged with a violation of probation. Would you like an attorney?
Yes, ma'am. Could you also tell me how I violated?
The affidavit alleges that you owe $50 cost of supervision and that you failed to provide proof of completion of 7 or more of the 55 hours of community service, and you failed to maintain enrollment in the Batterers Intervention Program.
I'm not done with probation yet, though.
Sir, I'm going to provisionally appoint the Office of the Public Defender. You're going to be held no bond. Your next court date is August 31st.
August 31st?
Yes.
And Judge, we still have Maria Jimenez Perez.
Awaiting an interpreter.
I called the interpreter first. Who's he on? Oh, he's there. Mr. Lopez, can you hear us?
Yes, Judge. Good afternoon.
All right. Ms. Jimenez,
Buenas tardes.
Good
you're
afternoon.
charged with, you're here on a capias that was issued for failing to appear for an arraignment.
Señora, usted está aquí por una orden de aprehensión que fue dictada cuando usted no se presentó para su instrucción de cargos.
That's a driving while license suspended or revoked case. Would you like an attorney appointed in that case?
Eso es por un cargo de manejar con licencia suspendida o revocada. ¿Usted quiere que se le asigne un abogado en ese caso?
Sí.
Yes.
I'll provisionally appoint the Office of the Public Defender.
Voy a asignar provisionalmente la oficina del abogado público en su caso.
Judge Groves set your bond at $1,000 on the capias for failing to appear.
Y el juez Groves fijó su fianza en $1,000 por la orden de detención.
Your next court date is August 14th.
Y su próxima corte va a ser el 14 de agosto, señora.
¿Puedo hacer una pregunta?
Can I ask a question?
Quickly.
Rápido.
Cuando se pague mi fianza, ¿puedo salir?
So once I deposit the bond, can I get out?
You can post a bond and get out, yes.
Sí, puede depositar fianza para salir, señora.
Gracias.
Thank you.
Good luck.
Buena suerte.
Is that it?
Is that it, Judge?
get the interpreter.
Thank you, Mr. Lopez.
Thank you, Judge. Good afternoon.
Central, do you have Pittman?
I have some scratched off to this, I don't know why.
It was a Bob, so.
I know he was here yesterday.
Franklin?
Oh, he was, I have down, well, unless I'm wrong, that the sheriff's website showed that he had been transferred on July 22nd. Is that
Good morning, Gil Barnett.
Good morning. How are you?
Good. I'm just gonna see if he wants to go forward without an attorney or with him, or without one. So I'm just gonna ask him first before we get started.
Okay. This might be entertaining.
I apologize. They just had something going on. He's coming down right now.
Okay, thank you.
They just offered rovers. They just had an incident going on there. Hey.
Thanks. Good morning. Thank you.
Good morning.
Good morning. Mr. Corona, I know you transferred to Garner, and I know that you did request an attorney's presence today. So do you want to proceed without an attorney today, or do you want me to continue to have counsel?
I'll proceed pro se.
Okay. Okay, so we'll get started then with your preliminary hearing. So good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Parole. This is a preliminary hearing concerning Corona Ulysses number 267628. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Gardner Correctional Institution. This is a public hearing, and public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Ulysses Corona, 267628.
Thank you. We have parole officer present. Can you please identify yourself for the record?
Parole Officer Bartnick.
This is a preliminary hearing, which is the purpose of the Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine to be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is at least place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibit file for the record. Counsel, the state will then have the opportunity to address the issue of probable cause and severity of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you of my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, you important rights today, right to have an attorney present, and you would like to continue without counsel, is that correct?
I will present myself, yes.
Okay, so you have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, I did.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
Okay, so we'll now review the charge the state appeals bringing against you and the information underlying each charge. So P.O. Bartnick, can you please read the charges?
Yep, so charge number 1 would be obedience to the law. On July 11, 2026, at approximately 12:45 a.m., Walter Brooks Halfway House staff were conducting a house count in your room. Staff member Russell Rogers accidentally bumped into your bed due to his flashlight going out. After you bumped into your bed, you immediately stood up and said, "What the fuck are you doing? I'm trying to sleep." The staff member proceeded to apologize for bumping into your bed. You then told the staff member, "I will fucking kill you." At this time, staff walked out of your room. On July 11, 2026, at approximately 8 a.m., you were outside during a supervised smoke break. During the smoke break, you approached staff member Russell Rogers again and said, "I will fuck you up if you do that again," which he was referring to when the Halfway House staff bumped into his bed during the house count on 12:45 the previous morning. Due to the threatening remarks that you made, Connecticut State Police Troop I were notified. Connecticut State Police arrived at the Halfway House to obtain statements and investigate this matter. Following their investigation, you were subsequently arrested and charged for CGS 53A-62, threatening second-degree physical threat. This violates your parole conditions, specifically obey all laws. Charge number 2, Halfway House placement. On 3/30/2026, P.O. Bartnick requested to review the contents of your phone, to which you complied, as there were reports that you were using your phone inappropriately while at the Walter Brooks Halfway House. Upon review of your phone, P.O. Bartnick discovered that you had photos on your phone of other offenders who were playing billiards in the recreation room, along with pictures of other offenders in the backyard during smoke break. In addition, there were photos of you smoking a cigarette in the Walter Brooks Halfway House bathroom. You admitted smoking in the bathroom of the Halfway House. Due to these findings, you're in violation of the Halfway House agreement, which you signed specifically. I will not photograph or record any portion of the program staff, or other residents at any time. And I may not use tobacco within the Halfway House. I may only smoke in designated areas at designated times. On April 3rd, 2026, at approximately 5:27 p.m., it was reported by Walter Brooks Halfway House staff that you were being verbally abusive with a food service worker staff at Walter Brooks Halfway House. It was reported that you told the food service worker, "I will lay you out if I see you on the streets." That remark violates the Halfway House agreement that you signed. Specifically, "I will treat others with respect, not engage in verbal or physical altercations with other supervised persons, staff, or third parties."
Thank you. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, remand to custody; B, signed parole condition; C, Halfway House placement; agreement; D, notice of parole violation; E, notice of parole rights; F, parole violation report; G, Connecticut State Police report ending in 9303; H, offender misconduct report 3/30/26; I, offender misconduct report 4/8/26; J, offender misconduct report 7/10/26; K, decision information summary; L, CT judicial pending case detail; and M is Rev summary 12/17/25. Did you receive notice of parole violation report, and those other documents that I marked? And did you review them, sir?
Yes, ma'am.
Okay. Do you need to continue this hearing to obtain any additional evidence?
I want all sound audio surrounding these allegations.
Well, would you like a continuance so that you can talk to counsel to obtain something that you're seeking?
I am the counsel.
Okay, well, we don't have that right now, or I don't even know if that is available. So do you want to proceed today without that, or are you requesting continuance?
Seeing as, because this is a limited evidentiary parole hearing, and it may exceed the scope of the purview of the investigative rigor applied in this hearing, I'll forego it, but my sound audio would demonstrate that I didn't speak those words.
Okay. So we have no witnesses today. At this time, I am going to swear you in, Mr. Corona, as well as P.O. Bartnick, in the event you would like to speak on your behalf today. So can you both please raise your right hand? You solemnly swear or sincerely affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
I do.
I do.
So at this time, the state will have an opportunity, if you'd like to make a short statement and testify with respect to probable cause, the severity of the allegations. You may at this time.
My claim is
Wait, it's the state's opportunity. So P.O. Bartnick, would you like to say anything at this time?
I'm sorry,
You're after him. Would you
I
like to
yeah,
say
I mean,
anything?
I believe it appears, I
apologize.
mean, I know you're on the docket for during arraignment about 8 times or 7 times. I'm not sure why it got changed so many times, but you were found to, during arraignment to be probable cause was found for the criminal charges of threatening second-degree physical threat. So, the judge already,
found probable cause.
determined that there was probable cause met for that. And the other ones, I mean, it was just staff reporting, which I have on with the incident reports and the misconducts. And also you did sign those misconducts, admitting to that those statements were true for the halfway house placement conditions. That's all I got.
Okay. So now it is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent if you so choose. Would you like to respond to the charges, Mr. Corona?
Yes. I simply want to state for the record, those infractions that were cited from the halfway house there were sanctions that were issued for my performance and behavior and things that I was required to do in order to stay compliant. And I completely fulfilled all the requirements of what was asked of me. I went above and beyond what was asked of me because at one time I was recommended by parole officer Bartnick to take an anger management course resulting from my parole stipulations due to my last situation, which I did do. I submitted to a therapist who did a full evaluation on me for mental health purposes and determination of medication, for which he sent me to an expert examiner to determine if I did need medication at any time for my specific case and condition, whatever the allegation was about my determined need for psychological treatment with medication. That officer determined officially on record, who was an expert from Yale New Haven Hospital, that no, I did not require any medication. That evidence was provided to Officer Bartnick, to the therapist and Officer Bartnick, officially stating that I didn't require medication. Secondly, I took the anger management course without fail every class. I also had 10 sessions with the therapist of individual therapy that I did without fail, satisfactorily completing all of that. In addition, I completed other programs when I was out there, the STRIVE program. I did obtain the certificate for that, which is employment readiness. The employment readiness program did provide me opportunities for employment, which I was awaiting response from one employer who had an opening for me. And I was actively seeking employment as part of my parole stipulation. The incident which triggered my violation is a legal matter that I intend to pursue, because for one, I want to subpoena all records and prove that those words were never spoken by me. And secondly, I want to show that even in visual view, there was no assaultive posture or action taken by me with my physical body or anything of the sort. In addition, I want to say here today, I came here yesterday from New Haven County to a cell where, not to go into extra detail, but I was tortured. And because of that torture, I was taken to SEG this morning without any physical resistance or any altercation that triggered any kind of emergency. I just simply was taken out of a torture situation and placed into SEG because basically,
well, this matter is a matter that you're gonna have to handle at the facility, so that's not pertaining to the violation today.
but I will say this, what I do want to get on the record is that, you see this suit? I'm in SEG because I was tortured. I came one day, first day, and wasn't able to sleep a night without sleep deprivation. And the fellow Russell from the halfway house was also sleep depriving me. And I told the judge, the judge yesterday, I have been getting tortured and I need to speak to a federal agent. And he said, I have to take it up when I get the attorney for the said incident, for this case, when I speak to the attorney, to procure a federal investigator. But I've been getting tortured in that halfway house every single day, sleep tortured, sleep deprived, and I was being starved at the halfway house. Starved? You can even ask the director, who knows that parole officer Bartnick knows as well. I made many, many claims that I was being starved and tortured by the staff and call it gang members or conspirators or whatever it is, who are also clients in the halfway house, ganging up on me, and I come over here and I get tortured again. So it lends further credence to what I'm saying.
Okay, so I've noted everything you stated today.
Thank you, ma'am.
So anything further from either side before I announce my findings? P.O. Bartnick, anything else further before I announce my findings?
No, just in terms of the anger management, mental health stipulation, that was a stipulation based from the board that you completed. The first misconduct I wrote, it was simply stating that you have to, comply with those conditions, which you did. I'm not going to say you didn't. So, but I'm just saying the misconduct that were written, you did sign and date them that you agreed. You weren't refusing that those things happened that were listed in those misconducts.
And I mentioned the medication because I was also forced to take medication here panel, and I'm complying with it and taking medication when I was found not to need any. So what I'm explaining is I'm under a torture protocol. I'm being tortured, and I'm taking the medication, but I'm being forced against my will to do many things, and I have no agency and no way out.
Okay, so I've noted what you stated as well, both state and as well as Mr. Corona. So those things are noted for the record. So what I'm going to do next, I'm going to announce my findings in regards to the charges that we read. So in regarding that charge 1, I do make a finding of probable cause, obey all laws, obedience to the law, based on evidence that was provided, which is exhibits B, G, and L. Regarding charge 2, I do make a finding of probable cause on halfway house placement based on the evidence that was provided, which is exhibits B, C, H, and I. I do find the act is serious enough to warrant revocation. I've turned to detain while you wait for revocation hearing. So when you get these charges disposed, we bring you back and we determine if there's a violation or not. Would you still like to have counsel contact you for the revocation hearing, or do you like to go with that on your own as well?
Would I still have who contact me?
Would you like to have defense counsel, the attorney, contact you for the revocation hearing, or do you plan to go ahead with it yourself?
I'll go with the attorney.
All right, so I'll have them contact you. They'll give you a call and talk to you about that, and they'll provide more information for you.
Yes.
Okay, so you're all set for today, sir. We will see you soon when those charges are disposed, okay?
Thank you, Penny.
All right, thank you. Have a good day, sir. Have a good day, P.O. Bartnick.
Thank you.
Thank you. Because I want to tell about the FBI. That's why I wanted the attorney to say that.
Good morning. Mr. Beck, can you hear me okay? Are you muted?
They're muted.
Can you have the officer come in so we can unmute you? Good morning, Attorney Olin.
Yes, good morning. How are you?
Good, how are you?
Good, thank you.
Now?
Perfect.
Okay.
Thank you.
You're welcome.
Mr. Beck, you can hear me now?
Yes, ma'am.
Perfect. All right,
Yes.
good. So we're here today for your revocation hearing, so we can get started with that. Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing starting Beck Thomas, number 299078. Today is July 29th, 2026. This hearing is being conducted via video at the VLPP Central Office in Cheshire Correctional Institution. This is a public hearing and public access. The hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Thomas Beck, 299078.
And you have counsel here today. Can you please identify yourself for the record?
Meredith Olin from the Law Office of Jason Goddard.
You. This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weight of evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for the hearing. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you had violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay. Your important rights today: right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence against you for the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
We will now review the charge the state your PO is bringing against you and the information underlying each charge. Charge 1, release direction of absconder. Your charging officer reported on 2/13/26. You walked out the front door, Bishop House. You're only approved PCS residence without authorization, leaving your whereabouts in the community unknown. Charge 2, under Obey All Laws drugs. Your charging officer reported on or around 11/25/25 you used cocaine, evidenced by a signed voluntary admission and positive test result of prohibited substances. And the state has filed the following exhibits pre-marked for identification as Exhibit A, parole violation notice; B, PCS conditions 2; C, half-ass agreement 2; D, offender misconduct 1; E, open heart incident report; E, voluntary admission; F, offender misconduct number 2; G, Bishop House incident report; H is remand custody order; I is parole rights; and Exhibit J is a parole violation report. Did you receive the notice of parole violation report, and those other documents that I just marked, and did you review them?
Yes, ma'am.
And I do have defense exhibits 1, list of parole accomplishments and future plans for parole reinstatement, and exhibit 2, which is solidarity counseling treatment letter. This was submitted by counsel prior. Would you like to keep these defense exhibits today?
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No, I did have a question though about the dates that you had recited for the allegations. I think that the 11/25 date might be, well, at least that's not reflected on my paperwork. I have the allegation for that as dated on 12/1.
Well, you could bring that up in the, because that's what I have on the notice. You're saying that you have a notice that says a different date?
The materials that I received in preparation for the hearing reflect a different date, so the incident reports and whatnot.
Well, you can bring that up in the, when we discuss the evidence.
Yes, sir. Yes, sir. Ma'am. I'm sorry, what's the best way for me to refer to you? I'm normally in front of judges, so I'm used to saying Your Honor. I don't know that that's appropriate.
Just the hearing examiner,
Hearing
Meisinger,
examiner.
P.O. Meisinger, either one's fine.
Thank you.
All right, so we have no witnesses today. I do want to put in the record, we did receive an addendum from PCS. The addendum states on 4/5/26, Beck Thomas was apprehended by Milford PD with no additional charges, transferred to FIU for transport to New Haven CC. This officer and PO Tribunal transported the absconder to New Haven CC without further incident. A warrant will be forthcoming from Ansonia PD for assault on public safety and evading responsibility. However, has not been signed. So that was the addendum that was submitted by PCS that we did receive. So it is now defense's opportunity. If you'd like to present evidence and speak to any of the evidence submitted at this time, you may now in regards to the charges.
Okay. Well, first, I would like to point out that in this notice of parole violation, that the allegation is that my client used cocaine on or about November 25th, 2025. In the incident reports that I've been able to review accompanying that notice, there's no indication that a cocaine test was even rendered on November 25th. Instead, the report indicates that my client was actually transferred from living with a loved one in the community to a halfway house on that date. So I did want to point that out. In terms of the sort of presentation of evidence in this, would you prefer that I solicit testimony in regard to some things from my client, or just that I?
Oh, you may. I'm just going to swear him under oath and that you would like to have him testify anything, because you may.
Thank you.
Mr. Beck, can you please raise your right hand? I'm going to swear you in today so you can make speak. You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
All right, go ahead.
Okay. Good morning, Mr. Beck.
Morning.
I want to ask you a few questions to kind of get us all on the same page in regard to the allegations that were made in your parole violation. And I want to start with the work that you had done in your facility before you got released to the halfway house. Can you tell me about the work that you did in regard to substance use and helping other people that have substance abuse issues?
Yes, ma'am. I volunteered to do the Tier 4 program.
Well, 1 second. Before, is this related to the violations itself? Because there's going to be another part where it's background and history and future plans. So I'm not sure if this is more appropriate for the second part, if it's not in regards to just the charges themselves.
So one of the allegations involves that my client allegedly used cocaine versus had contact with it. And I think that he's really significantly struggled with a loved one that had a serious substance abuse issue that ultimately resulted in, unfortunately, her passing. And part of, I think, the level of involvement he had in trying to help her achieve sobriety had to do with the experiences that he had gained while he was with the Tier 4 program right before his release.
Okay. You can proceed.
Thank you. So Mr. Beck, what were you doing with that Tier 4 program when you were volunteering with them?
In the beginning, I was just a regular tier resident. After about 9 months, I became a mentor where where I helped, where I would have like a 10-person caseload where I would help them navigate their way through the program and help them with their addiction issues and things that they were going on in their life that they struggled with. So I did that pretty much until I went home.
Can you tell me what is the purpose of the Tier 4 program?
Well, it used to, I always knew it as to be a Tier 4 drug program, basically to work on your addiction. But from when I took it and the counselors explained to me and taught me, it's more of a behavioral program in a sense of just teaches us the right things to do and teaches us about our decision makings and things of that nature.
Okay. And would it be fair to say then that by the time you were released into the community on parole, that you felt confident about your ability to work with people who had substance use issues?
Yes, I did. I became a certified recovery coach where if I wanted to get a job doing that type of work, I could do that work. Yes, ma'am.
Okay. And did there come a time after you were released into the custody of parole that you engaged in a romantic relationship?
Yeah, yes, ma'am. I came home in the end of June and was in that relationship maybe by the beginning of September.
Okay. And who was the person that you were in a relationship with?
Dana Samino.
Okay. And did you come to learn that Dana had some demons in her own life that she was working against?
Yes, ma'am.
Okay. And specifically, what were the issues that Dana had that she needed help with?
I didn't know in the beginning what they were, but I knew something was wrong. She had she had addictions with a lot of things, but I didn't know at first.
Okay. And when you found out, what were the steps that you took?
When I found out, in the beginning, I found out I didn't want to believe it. That's when I first paroled home to her house. I was only there for 2-3 weeks, and I found stuff in her medicine closet. I don't know, I just didn't want to believe it when I was finding. I was doing good. You used to say that again? What was my first what?
Sure. What actions did you take when you realized how bad things really were with Dana?
The first action was I tried to get her to MCCA, but I got sent back to the halfway house, and it was kind of easier for her to say that she wasn't getting high. So I kind of believed her in the beginning, but then she got pregnant. And, that's when I tried to. I was kind of I didn't know what to do at first, but it kind of led up to the situation of me running from the halfway house.
Well, we're going to get to that in a minute, but I want to ask you about your own drug use. Was there ever a time where you actually ingested cocaine on purpose?
I never did cocaine, none of that. Never in my life. Okay. Not once in my life.
So if you tested positive for cocaine, tell me about how that could have happened.
It did happen because I found it in the medicine cabinet, and she tried to rush me to the medicine cabinet first, and we both grabbed it, and it went everywhere, all over my hands, all over the sink, and it was in my pores. I never had a dirty urine after that. That happened in November. They gave me urines constantly every week. I've never had a dirty urine for cocaine. I just didn't want to tell that my sponsor was getting a high because I knew that would have forced me back in that halfway house, and I knew she needed my help. She kept saying that I was going to be the person to save her.
And would it be fair to say that you believed that you would be able to help her because of the background that you had as a mentor in Tier 4?
That and just maybe she seemed like she wanted to change. She wanted to change. She just had people in her life that kept bringing her down.
Now, was there a point where you also engaged in professional counseling to try and help her and try to help your relationship?
Yes, through parole.
Okay, and parole helped you do that?
The halfway house.
Okay, and what was the name of the counselor that you worked with Dana?
Vanessa.
Vanessa?
Erziri.
Okay, I would refer parole officer to one of our exhibits that were submitted by prior counsel, which includes a letter from Ms. Irizarry regarding my client's compliance with her treatment and also the reasons for the treatment. Now, I want to get to, and this is going to be the last series of questions I have for you. I know this is very difficult for you, Mr. Beck. You mentioned that there was a point where you had to go back to a halfway house because Dana was no longer approved as a person that you could stay with instead of being in a halfway house. When you got there, was there a point in time where there was an accusation made by an unknown person against you at the halfway house?
That happened when I went to back to Waterbury. Her drug dealer called the halfway house and said a lie that I was having her sell drugs and I was selling drugs so he could get me away from her. So he could basically just bully her and do what Ben was doing.
And did the people who were in charge at your halfway house search your room and also you after receiving that allegation on the phone?
They went through my phone and recovered 60,000 messages and it all yielded negative results.
Okay, so they didn't find anything in your room and they didn't find anything on you?
I wasn't doing nothing.
Okay, and the messages that they found on your phone, they were between you and Dana? Okay, now did you have Dana's cell phone number memorized?
No, ma'am.
So at some point they took your phone, is that correct?
Yes, ma'am.
All right, and when they did that, did you express to them your concerns about your pregnant girlfriend who had a substance use issue and that you wouldn't be able to get in touch with her?
I didn't tell them everything because I was hoping to go back home one day and I didn't want to let them know that she was struggling with addiction because I knew that they would have never let me go back there.
Did you ask for them to return your phone?
Yes, ma'am.
And what was their response?
To go upstairs and I'll give the phone back after they look through it.
Did you tell them that you needed your girlfriend's phone number?
Yeah, I'm pretty sure I did. I could have called. I could have called from the halfway house phone, but I knew at that moment. I didn't know what to do. I knew that he called the halfway house. I know that she was probably gonna go back to Bridgeport, getting high with the baby in her stomach. I just didn't know what to do. At that moment, I left and took her straight to detox. I didn't know what to do.
Okay, so you ended up leaving the halfway house so that you could get her to a detox facility.
I took her to McDonough House in Danbury for 4 days.
Okay, and
because around all this time is when I was really finding out what she was doing. Cocaine, Xanax pills, heroin, or fentanyl. When she wouldn't have the Xanax pills, she would run out in like a week. And I'm not knowing this in the beginning because she'd have a bottle of pills and she gets them from CVS. And I'm not paying attention to her medication like that because I spent a lot of time.
We don't need to, disclose everything she's using. I do understand what you're saying and how this is why, I'm assuming you left the halfway house and your explanation of why you left. Is that correct?
Yes, ma'am.
All right. I don't want to get too much further into your girlfriend's. I understand there's some things going on. I understand that completely. Is there anything else further in regards to these two charges?
I have one final question just to kind of complete the story, and then I should be all done with these questions. And this is probably going to be one of the more tough questions, Mr. Beck. Can you tell me what ended up happening with Dana and your child?
He passed away 12 days after me being incarcerated.
Okay. I have no further questions.
Thank you. And I'm sorry to hear about that, sir.
Thank you.
Sorry
Ma'am.
for your loss.
Thank you.
Right, so I have listened to all the evidence, I mean, I've read the evidence and I have listened to all the testimony provided today. So at this point, I'm just gonna announce my findings in regards to those two charges that I read. So in regards to charge one, I do find you did violate that condition release section of absconder based on evidence that was provided in support of the charge, which is exhibits B, H, G, and J. On charge two, I do find you did violate the conditional bail laws drugs based on evidence that was provided in support of that charge, which is exhibits B, E, and F. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to, at this time, speak to anything in regards to the second part of the hearing, you may now.
And that would be argument?
That would be anything in regards to future plans for release, things you've been working on, anything that will aid in me making the best recommendation.
Okay, great. Well, I'll first indicate that there have been some exhibits submitted by prior counsel that speak directly to the topics that I think that you need to review in making a recommendation. There's a pretty good discussion here about my client's work, his self-work, his work on himself, his compliance really with most of the things that he's asked to do. The series of events that gave rise to this revocation hearing were really a red herring that ultimately all boiled down to Mr. Beck being in love with a person who had a serious substance use issue. And I just want Mr. Beck to know that he's not alone in that. Unfortunately, huge portions of our country are being affected by substance use, not just because they have the addiction themselves, but because people they love are suffering with addiction and suffering with the effects that addiction can have on themselves, their lives, their families. And Mr. Beck attempted to use actually some of the tools that he had been able to build for himself in the facility, working with the programs that DOC had to offer. And unfortunately, there was a really just horrifically tragic ending to the love story that he had with Ms. Semino. And I would just ask that any recommendation that you make reflect that Mr. Beck's intentions were pure. His grief is very, very real. And there's no reason to believe that any of these behaviors would cause any kind of problem in the future were he to be re-released into the community, because all of the issues that are reflected in these reports ultimately reflect a moment in his life that has passed. And I'd ask that you take that into account. I believe the recommendation from the parole officer in the paperwork I was able to review was a period of 9 months. I'd ask that you consider more along the lines of a period of 3 or 4 months in terms of any kind of sanctioned recommendation for him. And thank you very much for your time.
Thank you. And I did read all the documents that was provided by counsel. And Mr. Beck, you still would like to go to your cousins? Is that still correct? Is that still an option?
Alyssa Espinal, yes, ma'am.
Yes, so that's still an option for you?
Yeah, I wish none of this would have happened if she would have knew I needed a place to go before.
Okay.
I just was trying to figure it out on my own and try to work things out with Dana, and just I didn't want to put no more pressure on my family.
So there's no changes to any of your release plans that you had previously stated to council? Okay. So I will be right with you with a recommendation. All right, so there are a few things I would like to put on the record before I make a recommendation. You were in the community about 7 months and 19 days before you absconded. You were in the community about a month and 23 days before you were returned to custody. I know that you were apprehended by Milford Police Department. There was an absconder warrant that was issued on March 11, 2026 by the parole board. You are on supervision, discretionary supervision right now until April of 2030. So you do have still a significant period of time left. I also do note that you do have that bond. So whatever happens today, you still, you have that bond amount remaining. So taking everything into account, the officer, as was previously stated, did recommend a 9-month sanction. I've listened to testimony today. I do take that into consideration, as well as the findings that were made today. So based on the totality of everything, I am going to recommend that parole be revoked and you be re-paroled for September 8th of 2026. This is approximately 5-month period confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, operation of motor vehicle, no contact with your co-defendants, Lamoni Skipwith, Jaron Smith, and Elijah Morning, no contact with your victims, XM, CM, CM, FR, and CR. My findings go on the parole board on August 13th. So you will receive official written decision from the board about a week after August 13th. So the board can lessen that sanction, they can keep it the same, or they can impose the sanction longer than what I've recommended. If the board wants a longer sanction, you're gonna have a supplemental hearing and you come back for to talk to the board about any reasons why they may want to exceed my recommendation. So just so you're aware that that is a possibility as well. Do you have any questions? You're gonna get this in writing about a week after August 13th from the board, what their decision is, as well as what conditions would be imposed at that time.
I do have one question. I'm sorry.
Go ahead.
How does so I have to wait until see what happens with court in order to have any final real decision, correct?
No, this is the parole board is going to make the decision on your re-parole date on August 13th. They're going to make the decision regarding this violation, what your re-parole date is. I don't know, you're going to you have to bond out on, if you have a bond, you have to bond out on that date if you still have that in order to be released, because you're still going to have that bond.
I don't think I could bond. I don't think I could bond out. I'm a sentenced inmate. I think I just have to resolve the case.
Well, we're giving you a re-parole date. Whatever re-parole date is, you'd be re-parole. If they, you'd have to see like what you may not be. You're not on special parole.
Yes, ma'am. I know I go to court in 2 weeks, and they told me they wanted to talk to parole first to see what they wanted to do.
Yeah, well, this is going to help finalize that. So after the board makes their decision, then you could see where you are with court.
Yes.
And then that's going to determine everything about when you can be released. So.
Yes, ma'am.
But at least this violation will be satisfied by, what the board's decision is, and then you can move forward with whatever new charges you may have. Obviously, if you get a new sentence, that's going to change some things as well. But as far as these matters concerned, those will be resolved and you'll know August 13th.
Yes, ma'am.
Okay?
Yes, ma'am.
All right. You are all set for today. Wish you the best of luck, sir. Thank you, Attorney Owen.
Thank you.
Have a good day.
Thank you.
Good morning. I think you're muted.
Good.
Perfect. Is it Mr. Figueroa?
Yes.
Perfect. Thank you.
Cool. Thanks, guys.
Thanks, Schaefer.
Anybody?
Good morning, Fioha.
Morning, how are you?
Good, how are you?
Not too bad.
Mr. Figueroa, we're going to get started with your revocation hearing. Attorney Dean, can you hear us? Have to wait for her to be brought into the meeting.
No problem.
I'm having trouble admitting her. Attorney
Okay.
Dean, if you could hang up and try to rejoin.
No, she was there. Attorney Dean, can you hear us at least?
Everything going okay?
Just waiting for somebody else.
Okay.
Kristen, should she just call in if this isn't working?
Yeah, I'm providing her that in email right now.
Okay. So she should be dialing in.
I believe she is connected now. Attorney Dean, can you hear us?
Hi, I can hear you now. I am so sorry. I'm not sure what's going on. It kept kicking me out of the meeting when I would log on and then wouldn't allow me to unmute myself.
Okay, so we're all here now, so we're gonna get started. Okay.
Perfect.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing, Attorney Figueroa George Jr., number 192694. Today is July 29th, 2026. This hearing is being conducted via video. The BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
George L. Figueroa Jr., 192694.
Thank you. And we have Parole Officer present. Can you please identify yourself for the record?
Parole Officer Huff, Hartford Special Management Unit.
Thank you. We have counsel here today. Can you please identify yourself for the record?
Yes, Hannah Dean on behalf of George Figueroa.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibit file for the record. The state will have an opportunity to present all relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. Do you have any questions about the purpose of procedure before we begin, sir?
No.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case at the hearing. You have a right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights? Am I ready to go forward?
Yes, ma'am.
So we will now review the charge, state appeals bringing against you, and the information underlying each charge. So, P.O. Hoff, please read the charges.
Sure. Charge number 1, obedience to the law. You failed to verify your address with the sex offender registry by failing to return a 90-day address verification letter on or before November 6, 2025. As a result, you were arrested and charged with violating Connecticut General Statute 54-252, sex offender registry failure to verify address. You were arraigned on June 3rd, 2026, when probable cause was established and a bond was set at $10,000. Charge number 2, halfway house placement. You possessed a second cell phone, which was discovered on your bed at the halfway house on April 30th, 2026. Possessing a second cell phone is in violation of your signed halfway house agreement and residential program electronic device disclosure form. On April 29th, 2026, while out on a pass to go to work, you were discovered riding your bike in circles in Polk Park where minors were present. When approached by the halfway house program manager, you stated that you had taken a wrong turn. You were previously directed to stay out of parks and other areas where minors may congregate. Going to locations not approved on your community pass is a violation of your signed halfway house agreement. Charge 3, problem sexual behavior treatment. On Sunday, April 26, 2026, you were sexting your sister, Janet, JF, the mother of your victim, asking, "Does it bother you when I tell you that you make me horny? And would you let me lick your ass and come on you?" Having contact with the victim's family is a violation of your signed Center for the Treatment of Problem Sexual Behavior Treatment Agreement.
Thank you. Could you please read the addendum that was submitted as well?
Sure. The offender was in court on July 2nd, 2026 under docket number H14HCR 26-07777754-S when the charge of violating Connecticut General Statute 54-252 failure to register sexual violence was dismissed. Offender Figueroa has no other pending criminal charges at this time.
Thank you. And the state has followed the following exhibits pre-marked for identification as Exhibit A, remand and actual custody order. B, parole violation report. C, notice of parole violation. D, parole community services signed conditions. E, Hartford Police Department arrest warrant. F, State of Connecticut Judicial Branch pending case detail. G, signed halfway house agreement. H, misconduct with evidence. I, the Center for Treatment of Problem Sexual Behavior Treatment Agreement. J, pictures, and K is instant offense police reports. Did you receive the notice of parole violation report, and those other documents that I just marked, and did you review them?
Yes.
Okay. And council has filed the following exhibits pre-marked for identification as Defense Exhibit 1, which is a list of parole accomplishments and 2 plans for parole reinstatement, and Exhibits 2 and 3, which are both maps. Do you need to continue this hearing to obtain any additional evidence?
We do not.
Okay. We have no witnesses today. At this time, I'm going to swear in P.O. Huff as well as Mr. Figueroa in the event you would like to speak at all today. So can you both please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Yes.
Okay, so at this time, the state will have an opportunity, if you'd like to present evidence, to speak to any of the evidence submitted at this time, you may.
Yes, I want to mention that this is offender Figueroa's 3rd remand to custody since
Well, do you have anything just regards to the charge?
Just that it's extremely concerning that these charges occurred probably within a week to 10 days of him being released to parole supervision. They're very concerning charges. I spoke to his CTPSB sexual behavior treatment therapist, and they firmly believe that his risk to sexually reoffend has dramatically increased in regards to this these most recent events, and that he is sexting his sister. He's riding a bike in a park he's not supposed to be, despite him saying that he was just riding through the park to get to work. I actually spoke to him previously and notified him that he used to go around the park because I knew which way he was going to have to go to work. I spoke to the program manager, Joe Gallant, about who discovered him in the park and said he did not ride through the park. He was riding in circles in the parking lot over there where there were kids present. Seeing that these behaviors and then having undisclosed phones, and again, sexting his sister, that's, shows that he's not really discriminating against who potential sexual partners would be anyways. It's extremely concerning.
Yo,
Yes,
Meisinger, if I could just, interrupt for a moment. The video has turned off at Robinson. If we could just ask the officer to come back in. I'm not sure that we'd be able to hear.
Can you hear us?
I believe he can hear us, but we can't hear him.
Okay, so can you get the officer so he can restart the equipment? I'm gonna pause the record at this time till we come back on.
I'll second.
Great. Thank you very much. Sorry if you have, you can continue. We're good. Thank you.
Yeah, just basically, I don't know where he left off anyways, but his IO is about him sexually assaulting his minor age niece, and he's hanging out in parks. He is actually sexting the niece's mother, which is the victim's mother, which is, it's just the culmination of all these, all these events anyways is extremely concerning.
Thank you for your statements. It is now defense opportunity. If you'd like to co-insist, present evidence, and speak to any evidence submitted at this time, you may.
Yes, thank you very much. As to charge one, I would just note that this was a situation where my client was previously remanded for a separate matter concerning the same charges for a date in August of 2025 that he already served a sanction for and was thereafter reparoled in April of this year. Unfortunately, the warrant concerning the present charge that had an incident date of November of 2025 was pending but not signed, or else he could have wrapped all of this up together, been served that warrant and potentially resolved that. Nevertheless, it's not new conduct that occurred between when he was most recently released and now concerning the Obey Laws charge. My client is currently compliant with the registry, is successfully registered. He made sure to do that as soon as he was released the last time. I will also note that the failure to register charge here, when he did go to court, was dismissed. So there were no convictions for that matter. As to the charge of halfway house placement concerning the Polk Park incident, I would argue first that I did submit 2 maps to show the route to get from my client's position where he worked at his father's tire shop and that area of Hartford over to the Eileen O'Connor house located on Irving Street. As you can see from the map submitted, the routes all go around or directly next to Polk Park. My client reports that he would take the route that brought him down Laurel Street to get to and from work. As you can see on the map, that is a little closer zoomed in. That is the recommended Google Maps route. I would just note, based on what my client has stated, he indicates at no point was he in the park near where minors were present. He indicates that he was driving around the perimeter past the parking lot. He indicates that when he spoke with the halfway house individual, he was under the impression that nothing was wrong. And didn't realize that, there was anything at issue here, as, this was, I believe, just the route he took to work. But he indicates that at no point was he in an area where there were minors present. And as to the allegations of the second cell phone, I would just note this is allegedly occurring on 4/30/26, which was, I believe, maybe 10 days after he was released from incarceration on special parole. So I will just note that he has indicated he was retrieving numbers from the new phone, and I would also indicate that that phone was confiscated and searched and had nothing of note on it, that second cell phone. But those are my arguments as to the charges. I would like to speak to his background at the appropriate time. Thank you.
Thank you. Anything else further before I announce my findings in regards to the charges from either side?
Yeah, I just want to again reaffirm the fact that he was previously directed to go around the park. I did know the path that he was going to be taking. He was directed to go around the park, and again, that the program manager, he stressed to me that he was not just riding through the park. And Mr. Figueroa also wrote the statement knowing that he was in the park and he shouldn't be, that he was sexting his sister, and that he broke the rules of his conditions. He knowingly broke the rules of his conditions anyways, and that he had 2 devices. One of those devices I did return to him upon him getting out because I thought that was going to be the one. We had agreed that was going to be the device that he got returned on. I directed him to delete everything that was on there because some of that stuff was regarding his last, or maybe not his last, his last violation anyways. So he did not delete all that as he was directed to do so. And the other phone, again, texting his sister or whatnot, is just the victim's mother is very concerning. So I'd also look to potentially have her added on his list of conditions to have no contact with her. And the work thing has a whole family dynamic, which is why I kept him back from work, because I guess both of his sisters go there, including the victim's mother and his other sister, who he calls Sexy 50. Just a pretty weird dynamic, which is why I did hold him back from going to work, because of the family dynamic at work anyways, but we can speak on that after.
Thank you. So I'll be right with you, my findings. All right, so I'm gonna announce my findings in regards to these charges. So in regards to charge 1, bail laws, obedience to the law, I make a finding. Although the charge is dismissed, I make a finding based on the evidence presented by the state exhibits D and E. I have noted though what counsel did say in regards to that charge. On charge 2, I do find you violated condition halfway house placement based on evidence provided in support of that charge, exhibits D, G, H, and J. On charge 3, I do find you violated condition problem sexual behavior treatment based on evidence provided in support of that charge, exhibits D, I, H, J, as well as testimony that was provided today. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So at this time, P.O. Hawk, would you like to say anything for the second part of the hearing?
Sure, just want to reiterate the fact that this is his third parole violation since being released, I believe in January of 2024, after serving 10 years for sexual assault in the first degree, which he was sexually assaulting his niece again, and he's been in contact with the niece's mother with sexually explicit messages. He actually claimed that it was his friend Betsy that he was texting when we initially discovered these text messages. We had called the number, spoke to Janet, who is his sister. She confirmed that these messages were sent to her. We asked her if she wanted to, what her thoughts on that were, and she said she did not want to talk about it, and that she was in treatment for it, which is why I would kind of recommend that he has that there's a no contact with the victim's mother as well, Ms. Janet Figueroa. The fact that he was sexually assaulting his niece and then hanging out in parks as well. This is extremely concerning, where there were minors present, as admitted by the program manager of the halfway house who discovered him in the park. And again, not just passing through the park, that he was riding in circles in the parking lot in the vicinity of minors. Because the culmination of these are very, again, in talking to the CTPSB therapist, that his risk to sexually reoffend has most certainly increased. Yeah, that's all I have for now.
Turn it over to counsel.
Yes, Mr. Figueroa is 59 years old, born and raised in Hartford. He does have a strong support system, various siblings, his father, aunts, uncles, and his wife, all of whom reside in Hartford. My client's wife does have significant medical needs, and he is her primary caretaker. He also does have 3 adult children. Most recently, upon release of special parole, he was at Eileen O'Connor Halfway House. Previously, while on supervision, he successfully completed both Stein and Watkinson halfway houses and then was sponsored by his wife at an address in Hartford. He also self-sponsored at an apartment through Chrysalis Center previously. For the last 2 years, he has been working full-time for his father's business in Hartford, which is at a tire shop. Most recently, as far as treatment goes, he began CBT at CRT in Hartford and was reportedly waiting to restart the CTPSB program. He does have primary care services established in Hartford. He does have prediabetes, high blood pressure, and then also a more recent kidney issue that he is anxious to get treatment for. Upon reinstatement of special parole, he is open to being placed at a halfway house in the Hartford jurisdiction. He hopes to return to his prior position with his father's business and is open to all treatment recommended, including but not limited to successfully completing the CTPSD program and reestablishing services through CRT. I am asking that you would consider re-paroling Mr. Figueroa on the first available board review date. As I noted, he did not have a DR during this period of incarceration. He keeps to himself, typically goes to work then home. He wants to move forward and get back out to help assist his wife with her medical situation as well. Thank you.
Thank you. What was the name, Keelhoff, that you were looking to have general contact order with?
The mother is Janet Figueroa.
What is it, Janet?
Janet, yes, ma'am.
Okay.
Janet.
All right, anything else further from either side before I take a minute to think about a recommendation?
No, ma'am.
Okay. All right, so I'll be right with
Nothing
you.
further. Thank you.
Thank you. I'll be right with you with a recommendation. All right, so there's a few things that I would like to put on the record before I make a recommendation. The offender was in the community only about a month and a half before he was returned to custody on these new violations. Although the charge was dismissed regarding the failure to register, I did make a finding on that, and with the evidence that I do have. There, as was noted, there are 2 prior violations that is noted by the officer that mirrors the behavior from the instant offense. There were 2 misconducts that were issued that I have noted on this period of supervision. The offender is on supervision for 12 years until 2036. So there is still a significant period of time to go for supervision. It is concerning that these behaviors occurred immediately, almost upon release. And it is the same type of behavior, which resulted in removal from problem sexual behavior treatment. So that is also very concerning, as well as the risk level being raised for the offender's sex offender level. So the officer did recommend an 8 months incarceration minimum. Taking everything into account, I am going to recommend that parole be revoked and that you be reparoled for February 2nd, 2027, which is approximately 8-month period confinement as a sanction. I recommend the following parole conditions: halfway house placement, preferably in Hartford, no contact with your victim, ZM, enhanced internet and device monitoring, mental health evaluation and treatment deemed necessary, no contact with minors without PO's permission, problem sexual behavior treatment, restriction on pornography, and a general no contact with JF. My findings are going to the parole board on August 13th. So the board's going to make the final decision. The board can lessen that sanction, let it stand, or impose a sanction longer than what I have recommended. If the board wants a longer sanction than what I've recommended, you'd have a supplemental hearing, and the board would talk to you about any reasons why they may want to exceed my recommendation. So you're going to find out on August 13th what the board's decision is. As was stated, they can make sooner you could be released. They can keep that date, or you can also be held in longer. Do you have any questions, sir?
No.
Okay, you will get
George,
this in
I will
writing.
set up a call with you.
Please do.
Okay, so
Okay,
like I
thank
said, you will get it in writing too from the parole board about a week after August 13th, what their decision is on this matter. Okay? All right, so I wish you the best of luck. You're all set. Thank you, Keelhoff. Thank you, Attorney Dean.
Thank you. Have a good day.
Thank you so much.
Good morning. Can you hear me?
Officer at McDougal, are you able to unmute?
Can you hear me now?
Yes. Is Attorney Dean still there?
Yes, I'm still over the phone.
All right, perfect. Making sure. Regarding inmate Michael Pizarski, number 329506, preliminary hearing has been waived and he will be scheduled for a revocation hearing upon disposition of his criminal charges.
P.O. Meisinger, I should let you know, I'm not sure if you received notice, but I am handling the hearing for Mr. Ford at 11 as well.
Yes, I have that noted.
Okay, thank you.
Thank you.
Sector only, and after 7 for the math program, E-sector.
Take the water.
Yeah, you drive, walk slow.
No, that's not what happened.
Pick up the pace.
Miscommunication.
Morning, Mr. Maxwell.
Good morning, how you doing?
Good, thanks. So we're gonna get started with your hearing. Attorney Dean, you're there?
Yes, I'm here. Thank you.
Perfect. All right, we're gonna begin. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Maxwell Rashawn, number 418090. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office and the McDougall Walker Correctional Institution. This is a public hearing. Public access to hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Rachel Anthony Maxwell, 418090.
Thank you. You have counsel here today. Can you identify yourself for the record?
Yes, Hannah Dean on behalf of Mr. Maxwell.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of facts, each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I'll consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we will review the charge the state appeal is bringing against you and the information underlying each charge. So charge 1 under bail law, they'll be against the law. Your charging officer reported on 11/25/25 at approximately 12:10 p.m. You were observed fleeing through the back door of residence that was under surveillance by Waterbury Police Department. Upon exiting the building, you began running away from Waterbury police officers, away from the residence towards the street. However, you were detained by officers. Search warrant was obtained by Waterbury Police Department for the residence you were observed fleeing from. Inside the residence you were observed fleeing from were numerous amounts of illegal narcotics, firearms, ammunition, large amount of money. You were subsequently arrested by Waterbury police officers for the following charges: violation of large capacity magazine, operation of a drug factory, sale of half-ounce cocaine, criminal possession of a pistol revolver, interfering with an officer, resisting, stealing a firearm, criminal possession of a firearm, ammunition, negligent storage of a firearm, and possession with intent to sell. Based on your actions, you're in violation of PCS conditional bail laws will be into the law. Charge 2 under bail laws, weapons. Your charging officer reported on 11/25/25 at approximately 12:10 p.m. You were under You were observed fleeing through the back door of residence that was under surveillance by Waterbury Police Department. Upon exiting the building, you began running away from Waterbury police officers, away from the residence and towards the street. However, you were subsequently detained by officers. A search warrant was obtained by Waterbury Police Department for the residence you were observed fleeing from. Inside the residence you were observed fleeing from were numerous amounts of illegal narcotics, firearms, ammunition, large amount of money. You were subsequently arrested by Waterbury police officers for the following charges: violation of large capacity magazine, operation of a drug factory, sale of half-ounce cocaine, criminal possession of a pistol revolver, interfering with an officer resisting, stealing a firearm, criminal possession of a firearm, ammunition, negligent storage of a firearm, possession with intent to sell, based on violation of PCS condition of bail laws of weapons. And the state is all the following exhibits that are pre-marked for identification as Exhibit A, CT remanded custody. B, CT signed conditions of parole. C, notice of parole violation, parolee rights. D, parole violation report. E, Waterbury Police Department reports. F, state of Connecticut judicial website information. G, previous parole violation report. And H, decision information summary. Did you receive notice of parole violation report, and those other documents that I just marked? And did you review them?
Yes.
Yeah.
Okay. And council's following exhibit pre-marked for identification as defense exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. I did receive the addendum from PCS. The addendum reads on 7/2/26, Mr. Maxwell appeared under docket ending in 7379T and pled guilty to interfering with an officer resisting. He was subsequently sentenced to 6 months incarceration. At this time, all open criminal cases are adjudicated. And I will note the end of sentence date for this sentence was on 7/2/26. Do you need to continue this hearing to obtain any additional evidence?
We do not. Thank you.
Okay, we have no witnesses today. So it's now defense's opportunity. If you'd like to call witnesses, present evidence, and speak to any of the evidence submitted at this time, you may.
Yes, thank you very much. I would argue as to the charges that there should be a partial no finding on charge 1 and a no finding on charge 2. We are not contesting that my client did accept a plea in court to the misdemeanor interfering charge. However, I did just want to put some information on the record concerning the more serious charges that he was initially charged with, specifically the weapon and drug charges. First, I want to note that the place where that was the subject of this search warrant here was not my client's residence. My client's on parole and is residing with his mother. Parole has that information and had to vet and verify that residence. Furthermore, based on the Exhibit E, which is the police on-site report from this incident, Mr. Maxwell was not the subject of the police's surveillance on this day at all. They were there to serve a warrant on another individual, and that other individual, in addition to one other person, were the subject of the surveillance. I will also note that the residence at question here is an apartment building. There is no specificity in the report that we have in evidence as to the apartment that the individuals were allegedly observed running from. When those individuals were eventually detained near the scene, everyone was found with the items of alleged evidentiary value on them, except for my client, who had nothing on him of significance. I will also note that everyone who was detained was essentially charged with all of the items that were found in the home. It wasn't, a situation where one individual was charged due to their proximity or something of that nature. Everyone was charged with everything. I will note my client has repeatedly stated he was not inside of this residence and was in fact outside. However, I will just note additionally, Exhibit E references supplemental reports that contain additional information concerning the surveillance and the arrest. However, that supplement was not included as evidence for this hearing. So I would argue based on that, the evidence that has been submitted, there's nothing showing that my client was connected to any of the alleged criminal activity here, or that he had knowledge of the firearms or drugs that were allegedly found in the home. Under the criminal jury instructions for possession of a firearm, pistol, or ammunition, possession does require that the individual is aware that they're in possession of that item and are aware of its nature, which based on the evidence here, I would argue has not been shown. I would also argue that the same applies for the possession with intent charges, that possession and knowledge thereof are essential elements. Relatedly, under the stolen firearm statute, again, an essential element is that the individual took, obtained, or withheld the firearm, which I would argue hasn't been established here based on the evidence. Lastly, I would just note that upon review of the evidence in the case, the state's attorney did not elect to prosecute those more serious charges and offered my client a 6-month flat sentence on that misdemeanor charge of interfering, which he did elect to accept in large part because he is on parole and knows he would likely be sitting in jail for a lengthy period of time awaiting trial for this case. However, I would just note that the prosecution had more information and knowledge about the facts and the available evidence and still did not proceed on those very serious charges, which tells me that there were likely evidentiary issues with the case as it applies to my client. Those are my comments concerning the charges themselves, and I would like at the appropriate time to speak to his background and history. Thank you.
Thank you. So I'll be right with you with my findings. Right, so I'm going to announce my findings in regards to those 2 charges. So on charge 1, I do find you violated conditional bail laws, obedience to law based on your conviction of interfering with an officer resisting, which is a sentence of 6 months jail, which was completed on 7/2/26. I do make a no finding on the remaining charges due to there being insufficient evidence to support those charges and those charges not meeting the elements of the offense. On charge 2 of bail laws weapons, I make a no finding due to the charge not meeting the elements of the offense. So that includes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. The purpose part of this hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, thank you very much. My client, Mr. Maxwell, is 33 years old, born and raised in New York until moving to Connecticut in the 11th grade. He has been in Waterbury since that time. He received significant support from his mom and grandmother. He also has 4 younger sisters who reside in New York, in addition to much of his extended family. Most recently, upon release to special parole on October 24th, 2025, my client was sponsored by his mom at the address provided in Waterbury. He obtained a flagging certification in December of 2022 through 4 Seasons Traffic Control, LLC. Most recently, he was actively searching for work and had an interview set up for the first week of December with Helping People Excel in Cheshire. Previous work experience includes the 4 Seasons Traffic Control in the Zone Bar and Grill in Waterbury. He does have a history of treatment, including App Foundation, Wellmore, and MCCA around 2024. Upon reinstatement of special parole, he would like to return to his mother's residence at the address in Waterbury. He does have an opportunity through a friend at Ability Without Boundary in Cheshire. As a backup plan, he's hoping to fill out a second application with Helping People Excel in Cheshire so that he can, further his job prospects. He's open to any sort of recommended treatment as well. I would ask that you would consider releasing my client on the first available board review date. He has been incarcerated on this since last November, and the sentence that he took in court has since expired. Since his remand, he has had no disciplinary reports, and I see no tickets while he was on supervision in the community. Thank you very much.
Thank you. So I'll be right with you with a recommendation. All right, so a few things I'm gonna put on the record before I make a recommendation. Bender was in the community about a month before he was returned to custody on his new charges, which did result in a new conviction for interfering with an officer resisting. He did complete that 6-month sentence at this time. There are no prior violations, as the last violation, Bender was reinstated after charges were nollied. He did receive 4 misconducts that were noted. I will note there is a history of drug sales that the offender is currently on supervision for. So it is somewhat concerning that seem to be around the wrong people. So, I would recommend maybe that start hanging out with maybe some positive influences, because obviously what you're doing right now is kind of leading to the same type of So based on the information that I have, the testimony provided, I am going to recommend that parole be revoked and that you be re-paroled for August 26th of 2026, which is an approximate 9-month period of confinement as a sanction. I recommend the following parole conditions, which is no contact with your co-defendants: Adam Guzman, Alexander Diaz, Ronnie Lennon, Christopher Ingenham, Donovan Hardison, and Rashawn Reeder. My findings are going to the parole board on August 13th. So you're going to get the official written decision from the board. If you're still there, you may be released before you get the paperwork, if they do agree with the date of the 26th. But the board can lessen it. They can let you out as soon as 8/13. That's as soon as you can get out. Or they can agree with my sanction, or they can hold you in longer. Just know that the board, if they want to hold you in longer, can call you back for a supplemental hearing. And they would discuss with you any reasons why they may want to exceed my recommendation. So you would have a chance to talk to them if they do want to have a sanction longer than what I've stated today as a recommendation. Do you have any questions? Okay. So,
Mr. Maxwell, I can set up a call with you. Oh, I'm so sorry. Meisinger, I was just going to let Mr. Maxwell know I can set up a call with you for the 13th to let you know what the board decides that day.
Okay, thank you. I'll like that.
Thanks.
You're all set, sir. Good luck.
All right, thank you. Have a nice day.
You too.
Can you hear me now? All right. All right, thanks.
Osborne, are you there? You're muted and the camera's off. Officer Meisinger, I just gave Osborne a call because it looked like they were connected but not answering. And she had rebooted the device and just asked me to give it a call in 1 more minute.
Okay. Sounds good. Kristen, is another room we can use if room one's not working at Osborne?
I was just on the phone at Osborne, and they're still having trouble, so I'm gonna dial room 2, and she's gonna see if room 2 will connect.
Great, perfect. Thank you. There we go.
Officer, you don't have the remote for the equipment, do you? I don't know if you can give I know you're not unmuted, so if you can give a thumbs up or thumbs down. Is there a remote in the room? Okay. But it let you press the button to turn the camera on, and right now we just can't turn the microphone on. Call back. In room 2, okay.
Okay, this on? Yeah. Okay, see, this one works.
Yes, I can hear you.
Oh, perfect.
Perfect. Can I see Massey first, please?
Okay, thank you.
Thank you.
Massey? You're the first one. Come on there.
Morning, sir.
Morning, good morning.
Morning. We're gonna get started with your revocation hearing, okay?
Okay.
Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Massey Kahari, number 3999994. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing and public access. The hearing is available at the video live stream. Please state your full name and DOC inmate number for the record.
Kahari Massey, 399994.
And you have counsel here today. Please identify yourself for the record.
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Massey.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact of each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is the preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, release you, and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you, and we'll review and identify exhibit file for the record. The state will then, counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. Rights to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
I did.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence for your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Are you ready to go forward?
Yes.
So we will now review the charge the state your appeal is bringing against you and information underlying each charge. So charge one, to obey all laws of obedience to the law. Your charging officer reported on 6/26/26. Parole is conducting a search of your vehicle at the Reach apartment. You're found in possession of various packages, approximately 21 individual pouches of marijuana and Ziploc bag and a backpack in the rear seat of your car. New London police charge you possession of over 5 ounces of marijuana. Per safety law, you should have stored some marijuana in the trunk of your car. When traveling with it in your vehicle, you admitted to buying the marijuana illegally from a bodega instead of a legal dispensary. A review of 2 cell phones found you revealed various text messages indicating you were selling drugs in the month leading up to your arrest. This violates 21A 277B1. And the state has filed the following exhibits pre-marked for identification as Exhibit A, notice of parole violation; B, remand of custody order; C, parole violation report; D, signed parole conditions; E, screenshots of 2 cell phones found in Massey; F, picture of marijuana found at Reach apartment 6/26/26; G, New London police report; H, Connecticut general statute language; I, 2 disciplinary reports; J, parole decision summary. Did you receive notice of parole violation reports, and the other documents I marked? Did you review them?
Yes.
And do you need to continue this hearing to obtain any additional evidence?
No.
So it's not a defense opportunity. If you'd like to call witnesses, present evidence, and speak to any evidence, any of the evidence submitted at this time, you may.
Yes, on behalf of Mr. Massey, I know this is a revocation hearing and it's very unusual, but I am asking that a no finding be made on the singular charge of obedience to the law. And the reason I am asking that a no finding be made is my client, with the parole officer, the statute 21A-279A/D/1, that is a violation. There's not a criminal offense which carries any jail time. The max penalty on that violation is a $500 fine. So I am asking that a no finding be made. I do have a printout that I was able to obtain from JIS, which indicates my client did go to court in New London on GA10 on July 27th of 2026. A $50 fine was imposed and it remitted a judge. So the case has been resolved, and that particular conviction is a violation. Once again, it's not a criminal offense. And the other sentence regarding the cell phone and the exhibit, I believe it's H, that was submitted, is not applicable here. My client was not charged with any of that in court. The singular charge was just a violation, and I'm asking that his parole be reinstated today. Thank you.
Thank you. I'll be right with you with my findings. So regarding that charge, number one, conditional bail laws, obedience to law, I make a no finding due to the charge of 21A, 279A, B1 being a violation, which is non-criminal. There is also no finding on the charge of 21A, 277B1 due to there being insufficient evidence in the charge not meeting the elements of the offense. So due to the no findings, your parole is going to be reinstated today without modifications to your conditions. I'm not sure if you have bonds.
Currently, I have a $50 bond for the other case in Norwich. Norwich told me that they're basically gonna go and coincide with whatever New London did. That
So,
was,
so Harry, don't put anything else on the record. I just
Okay.
need to know, do you have access to call your mother today, or do you need me to do it for you?
I'd rather you call her.
All right. So I know this is public. You okay with putting her phone number? I just need her number.
Yes, 475.
Go ahead.
355-1514.
And her first name?
Rhonda.
Okay, that's all I need. That's all I need.
Are you looking to go, do you need a halfway house placement, or are you looking to return back to, a sponsor?
Halfway house in New London, please.
Halfway house in London? Okay. Or Norwich?
Yes.
Norwich. All right, so I'm gonna notify the officer, as well as records. So that is, concludes this hearing today.
Thank
Okay?
you. So Harry, I'll take care of that call, and hopefully your mom can come down and get you out today, okay?
Thank you, Mr.
All right.
Thank you.
All right, take care. Thank you.
Have a good day.
Caitlin.
Yeah, have a good one.
Have a good day, Attorney Sergio.
Yeah, you too. Thank you.
Yes, ma'am.
Hi, who your name is?
Hi, can I see Ford, please?
Okay, Ford.
Morning, sir. I'll be right with you, okay? Attorney Dean, are you there?
Yes, I'm here.
Okay, I'll be right with you.
Thank you.
Okay, so we're gonna get started with your hearing. Good morning, I'm P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ford Reggie number 276597. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Reggie Ford, and my number is 276597.
Thank you. You have counsel here today. Please identify yourself for the record.
Yes, Hannah Dean on behalf of Mr. Ford.
This is a preliminary hearing, which is the purpose of our Connecticut law is to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine the act is sufficiently serious to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I will reinstate your parole, which is releasing and place you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of the hearing I determine you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know preliminary hearing is an adversarial proceeding, and if you state this hearing can be used against you, this hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to address the issue of probable cause and severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay, important rights say you like to have an attorney, and you have one here today. You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to follow and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand your rights and are you ready to go forward?
Yes, ma'am.
We now review the charge the state your appeal is bringing against you, any information underlying each charge. Charge 1, under release section GPS, your charging officer reported you have had multiple GPS violations since May 7, 2026, which is violation of your GPS agreement. Charge 2, curfew. Since May 7, 2026, you've committed numerous curfew violations of your GPS monitoring agreement. Charge 3, under bail law, obedience to the law, your charging officer reported on 8/25/25. Mr. Ford's operating motor vehicle in New Haven, Connecticut. He stopped by New Haven police and it was determined he did not have valid insurance. As a result, he was issued a citation for illegal operation of motor vehicle without minimum insurance. Charge 4, drugs. Charging officer reported the defendant has consistently denied cocaine use despite testing positive for cocaine on the following dates: 2/27/26, 3/9/26, 3/24/26, 6/3/26, and 6/17/26. Charge 5, no driving. Your charging officer reported on 8/25/25, Mr. Ford's operating a motor vehicle in New Haven, Connecticut. He was stopped by New Haven police and it was determined he did not have valid insurance. As a result, he was issued a citation for illegal operation of motor vehicle without minimum insurance. He did not have permission to operate a motor vehicle. And the state has filed the following exhibits pre-marked for identification as Exhibit A, signed conditions of parole; B, notice of parole violation; C, remand in custody; D, parole violation report; E, premier of outside lab reports; F, misconduct; G, referral to Apple Foundation; H, app discharge letter; I, New Haven police report was not received; J, judicial printout of docket ending in 8114-F, and K is GPS reports; L is GPS agreement; M is prior PVR information, and Exhibit N is the disc. Did you receive notice of parole violation report, and those other documents that I just marked, and did you review them?
Yes, ma'am.
We have.
Okay. And do you need to continue this hearing to obtain any additional evidence?
Not at this time.
So it is now defense's opportunity to respond, make short statements, or testify with respect to probable cause to the severity of the allegations. You may at this time.
Yes, I would just note, my understanding is that top placement was recommended. In the event that we could move to that part of the hearing, we would waive the first part of the hearing.
Okay. All right, so I'll accept the waiver. So we will go to the second part of the hearing. I do find the act serious enough to warrant revocation. So as was stated, Department of Corrections did recommend you for diversion from the revocation process for substance abuse program and treatment. This means if you want to participate, apply, and I find you meet the criteria, I can continue your case while you provide an opportunity to participate in the substance abuse programming and treatment in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked or if any sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and would you like to apply for it?
Yes, ma'am.
So I will announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. So I have reviewed all the relevant information. My finding is as follows. I find you have no pending misdemeanor felony charges. I find that your discharge date is more than 60 business days from date of your return to custody. I find there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you received or provided with an opportunity to receive substance abuse programming and treatment during your period of parole supervision in the community. So I have determined you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask you to indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment and that parole revocation proceedings may be delayed as a result.
Yes, ma'am.
I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed. It is conditioned upon my successful completion of the TOP program.
Yes, ma'am.
I understand that ultimately the DOC will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes, ma'am.
I understand that my participation in this process is completely voluntary.
Yes, ma'am.
Okay, so your application for diversion is granted and you're placed in the treatment or programming by DOC and diverted from revocation for no more than 60 business days. Okay, so as long as you complete that, I'll be notified and I will reinstate your parole. Okay?
Yes, ma'am.
All right, you're all set. Good luck with everything, sir.
Thank you.
Have a good day.
Good luck. Thank you.
Thank you.
Thank you, Attorney Dean. Have a good day.
Thanks. You as well. Take care.
Good evening, next.
Can I see Mr. Weatherwax, please, and then Smith?
Okay, Weatherwax. Weatherwax.
I'm deaf. Morning.
Morning, sir.
How you doing today?
Good. How are you?
Good, thank you.
We have Mr. Weatherwax, and then I'm going to do Smith. POBQ's here. Perfect. You can hear us okay?
Yeah,
Perfect.
I'm doing all right. Yeah, I am hard of hearing, just to let y'all know, but I got you. I can hear you right now, though.
Okay. I'll try to talk slowly so you understand. Okay?
Okay. Yes, ma'am.
If you don't understand or you can't hear me, just let me know.
Okay.
You all set, babe? Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Weatherwax Joseph, number 304462. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. This is a public hearing. Public access for the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
It's Joseph Weatherwax, 304462.
And we have a parole officer present today. Can you please state your name for the record?
Hi, good morning. Parole Officer McHugh, Hartford Parole.
Thank you. We have counsel here today.
Thank you. Attorney Sonia Jones on behalf of Mr. Weatherwax.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better weighted evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge that the state your PO is bringing against you. I will review and identify exhibit file for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all of the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
So far, no, ma'am. Thank you.
You have important rights today. You have a right to have an attorney, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So we will now review the charge the state your PO is bringing against you and the information underlying each charge. So PO McEwen, can you please read the charges?
Sure. So it looks like two separate charges. First charge was obedience to the law. So on April 30th of 2026, you were involved in a motor vehicle accident and police were contacted. During the investigation of the accident, you were observed to have signs of impairment. A field sobriety test was administered by PD that you failed. Subsequently, you were arrested by Manchester PD in the following charges: Connecticut General Statute 14-227A, illegal operation of a motor vehicle under the influence of alcohol or drugs, and Connecticut General Statute 21A-267, parentheses A, use of drug paraphernalia. We had a court date of May 28th, 2026 out of Manchester, GA12 under docket H12M-CR26-0301973-S with companion docket H12M-MV26-0487938-S. Charge number 2 is drugs. On April 30th, you were involved in a motor vehicle accident and police were contacted. During that investigation of the accident, you were observed to have signs of impairment. A field sobriety test was administered by PD that you failed. During this investigation, a crack pipe was also located in the vehicle that you were driving. Subsequently, you were arrested by Manchester PD on the following charges: Connecticut General Statute 14-227A, illegal operation of a motor vehicle under the influence of alcohol or drugs, and Connecticut General Statute 21A-267, parentheses A, use of drug paraphernalia. You have a court date of May 28th, 2026 out of Manchester, GA12 under dockets H12M-CR26-0301973-S with companion docket H12M-MV26-0487938-S. And then on this same one, on May 5th, you were reported to the Hartford District Office. You rendered a toxicology screen that was positive for cocaine and marijuana, and you signed a voluntary admission admitting to that use.
Yes. And then can you please read the addendum that was issued?
My computer is actually frozen. I was trying to get it. So can you please read the addendum?
Oh, sure. On 4/30/26, Smith inmate number 304462 was arrested on the following charges of illegal operation of motor vehicle under the influence of alcohol or drugs and use of drug paraphernalia. He was given a next court date of 5/28/26 out of Manchester, GA12. On 7/9/26, Mr. Weatherwax pled guilty on the charge of illegal operation of motor vehicle under the influence of alcohol or drugs and received a sentence of 6 months jail, execution suspended after 2 days with 18 months probation and a $500 fine under docket ending in 7938-S. Court records state that the case docket ending in 197-S companion to motor vehicle was disposed as of the same date. The state has filed the following exhibits pre-marked for identification at Exhibit A, remand to actual custody; B, conditions of parole; C, notice of parole violation; D, parole violation report; E is State of Connecticut Judicial Branch pending case detail; F, Manchester PD incident report; and G is voluntary admission. Did you receive the notice of parole violation report, and those other documents I marked, and did you review those?
You speaking to me? Yes, I did.
Yes,
Yes,
yes.
yes,
Okay.
yes.
And council has filed the following exhibits pre-marked for identification as Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement, and Defense Exhibit 2, which is a support letter. You need to continue this hearing to obtain any additional evidence.
No.
Okay, we have no witnesses today. At this time, I am going to swear in Mr. Weatherwax as well as P.O. McHugh in the event you would like to speak today. So can you both please raise your right hands? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
Yes.
Yes, I swear.
Okay, so at this time, the state will have an opportunity. If they'd like to present evidence and speak to any of the evidence submitted, you may at this time.
I have nothing additional to say.
Okay, so I'm going to now turn it over to counsel. If you'd like to say anything in regards to the violation.
Just that the addendum is stated accurately. No further comments as to the charges.
Thank you. So I'll be right with you with my findings. So regarding that charge 1, I do find that you violate conditional bail laws, obedience to law. This is based on your conviction of operating under an influence of alcohol or drugs and received a sentence of 6 months jail, execution spent for 2 days with 18 months probation. I also make a finding on use of drug paraphernalia based on the evidence presented by the state, which is exhibits B, E, F, and D. Although not convicted of that offense, I do find the behavior meets the elements. On charge 2, I do find you violate condition obey all laws drugs based on evidence provided in support of that charge, exhibits B, D, F, and G. There's a no finding on marijuana use as it fails to meet the elements of the charge of drugs. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So P.O. McHugh, do you have anything you'd like to say for the second part of the hearing?
Yeah, so I was just kind of reading through what was sent over for his future plan, which I did think was great. I just wanted to clarify. So Weatherwax, you're planning to go in with your wife's parents, is that right?
Yes, because we know the situation then was a little rocky at home. I want to go to the in-laws house and stay there, work on my marriage at the same time. And
Okay.
yes.
So I just wanted to float out the option. It doesn't have to get figured out right now. A sober house might be a good idea for you just for a period of time to establish some sobriety. We don't have to decide it right now. It's just something that I did want to point out because you had done it, but you only did it for a day. You have a lot of family triggers, which is completely normal and completely okay. We just want to be supportive of you. So if you want to make that change and decide to do something like that, just think about it that way. We can make the change before you come back out, okay?
Absolutely. Thank you.
Nothing further from the state?
Nothing further.
Okay, turn it over to counsel.
Yes, thank you. My client's 44 years of age. He's married. He does have 2 children, biological children, 24 and 13. He has 3 stepchildren. His primary community support includes a men's group at his church, the Hope Springs Church, located in Safford Springs, Connecticut, as well as his adult daughter, who's 24, located in Winsted, as well as his wife and his in-laws. He is a high school graduate. He has attended some college as a Nantucket Community College. He was in the community during this period of supervision, having first been released to full supervision on July 10th of 2024. So for approximately 22 months prior to being remanded. I believe this is his first violation of his parole. He did first go out to a sober house, but was only there for approximately 1 day before transitioning to sponsor with his wife. During the time period that he was on supervision, he reports attending a men's group through his church. He also reports successfully completing a weekly men's group at Hockanum Valley Community Council. That was a substance abuse group that he attended for approximately 4 months. He was gainfully employed, most recently working at Jake's Foundation in Ashford, Connecticut. Was working there, he indicates, about a month after his release to supervision and remain there full time up until the point where he was remanded. That is evidenced in Exhibit 2, which is a letter of support from his employer. During the time period that he's been within the Department of Corrections, he reports participating in Alcoholics Anonymous meetings. When he is released back to supervision, as indicated, he would like to be sponsored by his in-laws, Rose Daigle and Ron Daigle. Their information is contained within Defense Exhibit 1. He did have aspirations and discuss with me that he would like to go to a sober house. However, certainly that would have to be set up prior to him being released, and that's difficult when people don't know when they're going to be released to set that up because you have to pay for it up front. So that is something that we discussed. He's certainly amenable to it. However, the in-laws provide him with a residence where he can go to at least initially get started back in the community. He does have his employment to return to at Jake's Foundation. And in terms of education, he does indicate that he's interested in returning to a manufacturing program and completing any required credits that he has remaining. And that was a program he was participating in while attending college. He is open to all treatment recommendations, including but not limited to a dual diagnosis, outpatient services for ongoing support and psychoeducation. He's eager to continue working with his men's group in church for additional support as well. I would just note he did have that conviction in court. He did plead guilty as a first offender, operating under the influence charge. And I just think it's important to note that obviously when someone pleads guilty as a first offender, there's a suggestion there that they were not eligible for the program. And certainly his first DUI arrest did occur back in 2007. And so that was 19 years ago. I just think it's important to note that that was a significant period of time ago. We would be asking that he be re-paroled at the next available date, taking everything into consideration. Thank you. Thank you.
Is there anything further from the state before I make a recommendation?
Nothing further to add.
Thank you. So I'll be right with you with recommendation. All right, so I'm going to put a few things on the record before I make a recommendation. You were in the community approximately a year and 9.5 months before you were returned to custody on the new charges, in which you did receive a new conviction for illegal operation of motor vehicle under the influence of alcohol or drugs, and you did receive that new sentence in which you need to serve 2 days with 18 months probation to follow. There are no prior violations noted on this period of special parole supervision. You did receive one noted misconduct. I did note, and as was stated by counsel, there is a prior conviction for DUI that was back in 2008. But this is not the first time the offender has been convicted of this type of offense. If officer did recommend revoke pending dismissal of charges, based on all the information that I have, I am going to recommend that parole be revoked and that you be re-paroled for September 2nd of 2026 with approximate 4-month period confinement as a sanction. I recommend the following parole conditions: no consumption of alcoholic beverages, no contact with your co-defendant, James Weatherwax, without PO's permission, mental health evaluation and treatment deemed necessary, operation of a motor vehicle, no contact with your victims, K, S, and BT, general no contact with One Stop Deli and Convenience Store, 397 Enfield Street, Cumberland Farms, 1439 New Litchfield Street, Torrington, Mobile Gas Station, Winstead Road, Torrington, Connecticut, Shell Gas Station, 241 Hazard Ave, Enfield, and JS. So my findings are going to the parole board on August 13th. So the board's going to make the final decision. So they can let you out as soon as 8/13, anytime in between. They can agree with my sanction, my 4-month sanction of release on September 2nd, 2026, or the board can hold you in longer. If the board wants to hold you in longer, they bring you back to have a supplemental hearing and they would talk to you about any reasons why they may want to exceed my recommendation, and you would come back and answer their questions. That's only if they want a longer sanction than what I've stated, okay? Do you have any questions, anything that I have said?
So right now you recommended September what? I didn't hear the date.
September
September
2nd, which is 4 months since you came
Okay.
in.
And
I'm
when
trying to give you some more time in the facility. I want to make sure that you have enough clean time and that you're getting some type of, keep participating in the meetings that you're participating in and stay active and plan out, you know, what you're going to do when you come out and where you're going to go for treatment and work with your PO so that you have a good plan set up when you get out.
Absolutely. And when would I hear from parole if they were to change, not agree with that?
Well, you're gonna know August 13th, during that week, you're gonna get paperwork from the parole board and it's gonna say what the board's decision is. And it's gonna say, what conditions that the board issues, and I'm not sure.
Yeah, so Joseph, if you want to reach out to me after August 13th, I can let you know what the board decided, okay?
Okay, thank you. Yes,
Yeah.
ma'am.
All right, work with your parole officer, make sure you get the treatment you need, okay?
I absolutely will.
Sorry, Weatherwax, I didn't mean to cut you off. It just for when it comes up on the 13th and you do talk to your lawyer, there are basic needs programs that will cover sober houses. That means you don't have to pay out of pocket for it if that's something that you guys want to discuss. Again, you don't have to, just something that's there.
Okay, and that actually might work a little better too, September 2nd. It'll give me the option to go find a parole. and
I'm
sober
trying to
house.
give you a couple extra weeks to work on getting things
So that's a
concrete,
blessing.
okay?
Thank you, Q. Thank you.
All right, good luck, sir. You're all set.
Thank
Thanks,
you.
everybody.
Good luck, Joseph.
Have a good day.
You too.
Have a good day.
You too.
Thank you.
Mr. Smith, yes.
Oh.
I'll be right with you, Mr. Smith, okay?
Okay.
All right, so we're gonna get started. Good morning. I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Smith Kenneth number 059714. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office and Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record, sir?
Kenneth Ray Smith, 59714.
This is a preliminary hearing. Oh, you have counsel here today. Please identify yourself.
Yes, thank you. Attorney Sonia Jones on behalf of Mr. Smith.
This is a preliminary hearing, which is the purposes under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine the act sufficient serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of the hearing I determine you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. And this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to just issue parole calls for the severity of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No, I don't.
Okay, you have important rights. You have the right to have an attorney present. You have counsel here. You have a right to see the written notice, charges of violation. Did you receive the written notice?
Yes.
Okay, you have a right to view the evidence against you for the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. You understand these rights and are you ready to go forward?
Yes, ma'am.
All right, and I'm going to swear you under oath so that you can speak today if you'd like to. Can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, ma'am.
Just for clarification, before we begin the hearing, I just wanted to note that his parole officer recommended top diversionary program. However, noted that my client did not receive any treatment in the community. And just by way of clarification, my client did tell me that he was attending CCAR in Waterbury through the dates of April to September of 2025. My social worker reached out to a representative from CCAR, Virginia Adams. She was able to confirm that, yes, my client was attending CCAR during that time period, specifically participating in several peer recovery-oriented groups and support meetings weekly, as well as volunteering at the center. And so if I can just ask Mr. Smith a few questions in regards to that. Mr. Smith, during the time period that you were working with the CCAR program, you were participating in peer recovery-oriented groups. Did those groups focus on substance use issues?
Yes, he did.
Okay. And did those groups also focus on ways for you to maintain your sobriety while in the community?
Yes, he did.
Okay, thank you. If the hearing examiner is willing to accept Mr. Smith's participation at CCAR as treatment in the community, we would be willing to waive the first portion of the hearing and ask that my client be placed in the top program.
Thank you. So due to the information that clarified he was participating in substance abuse treatment while in the community, I will accept the waiver for the first part of the hearing. And I do find the act was serious enough to warrant revocation. So DOC did recommend you for the diversion process for substance abuse program and treatment. This means if you wish to participate, apply, and I find you meet the criteria, I can continue your case while you provide an opportunity to participate in the program and treatment in correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a rev hearing to determine if you violated conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked or a sanction should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you want to apply for it?
I don't understand what the diversion part of this is.
The top program that you are currently participating in, is that correct?
Yes, yes,
So
yes, ma'am.
this is to determine your eligibility and determine if you would like to remain in that program or be in that program. That's why you're having this hearing today, because you have to be placed there by the parole board.
Yes.
So you would like to apply to stay there and continue participating, correct?
Yes, I've already begun already.
Okay, so that's good. So I'm going to announce then my findings with respect to your eligibility. If I determine you are eligible, I can accept your application and divert you from application. So I have reviewed all relevant information and my finding is as follows. This includes the testimony that was provided today by you, Mr. Smith, as well as the attorney. So I have determined you are eligible for diversion for substance use programming and treatment. I do find that you have no pending misdemeanor or felony charges. I find your discharge date is more than 60 business days from the date of your return to custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor and it's fair to comply with terms and conditions of parole. And I find there is some evidence that you received or provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. So before I accept your application for diversion, I ask you indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result. Do you understand that?
Yeah, I think I do.
Okay. Go ahead.
Does that mean that I have to remain in the program until the program discharges me from the program?
Yes, you have to complete the programming. If you didn't complete it, we'd have to schedule you for a revocation hearing, and then you come back, and those proceedings may be delayed a little bit because of your participation in the top program now. That's what that means. I understand I will remain incarcerated while I receive the programming and treatment and that parole revocation, that's why it's red. I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of the top program. You understand that? That means if you complete the top program, that's when your parole will be reinstated.
Okay, yes, I understand that now.
Okay, I understand that ultimately the DOC will determine whether I have successfully completed the top program.
Okay, yes.
Okay. I understand that my participation in this process is completely voluntary.
Yes.
So your application for diversion is granted. You're going to be in the programming and diverted from revocation for no more than 60 business days. So as long as you successfully complete the program, that means no DRs, you don't get removed from it. I will be notified and I will reinstate your parole.
Okay.
Okay?
I understand that.
So you are all set, sir. You just keep doing the program and hopefully you'll be all set when you come out.
Okay, thank you very much.
All right. Good luck, sir.
Good luck, Ken.
Okay, thank you.
Have a good day.
What's this? Gotta go to the program, but.
Morning, sir.
Morning, how you doing?
Good, Mr. How do you say your last name?
Ferris.
Ferris?
Yes.
I'll be right with you 1 second, okay?
Yeah, take your time.
All right, we're gonna get started with your hearing. Good morning, I'm P.O. Meissner, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Brian number 322796. Today is July 29th, 2026. This hearing is being conducted via video at the BOPP Central Office in Osborne Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Brian Bears, 322796.
This is a preliminary hearing which is the purposes under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show that there is probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is at least to place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Correction for diversion for substance abuse programming and treatment. If by the end of the hearing I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you if this hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibit file for the record. The state will then have an opportunity to address the issue of probable cause, the severity of the allegations. The state isn't here today, so you will have that opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. So you have important rights today, the right to have an attorney present. Do you want to continue or move forward without counsel?
Yeah.
You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
Okay. You have a right to review the evidence against you before the hearing. You have a right to submit evidence in support of your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
So we will now review the charge the state your parole officer is bringing against you and the information underlying each charge. So charge 1 under police structure residence, your charging officer reported on 7/12/26. You left the premises of the Chase Center halfway house without an authorized community pass or permission from halfway house staff or parole. Chase Center located at 21 Cliff Street, Waterbury was your only parole-approved address. From 7/12/26 to 7/14/26, you did not make any effort to return to the halfway house, contact the halfway house, contact parole. Whereabouts committee were known until 7/15/26 when you contacted parole to report you were at St. Mary's Hospital in Waterbury. Charge 2 under bail was drugs. You're charging off support on 7/12/26. You tested positive for cocaine. On 7/15/26, you tested positive for cocaine and fentanyl. On charge 3 under additional condition halfway house placement, your charging officer reported on 7/12/26. Chase Center gave you an authorized community pass to do shopping at Walmart from 1 to 3:45. You returned to the halfway house at 3:09 without any purchases from Walmart. When Steph asked you for a receipt, you reported you went to the corner store at Five Below. You deviated from your approved pass for 1 hour and 9 minutes. Upon checking you back into the halfway house, the urinalysis was conducted. You reported and signed a voluntary admission form using cocaine while on your community pass. UA results were positive on the instant cup. Due to being under the influence of cocaine, your pass for work that evening was revoked by Chase Center area director. You're in violation of halfway house agreement, which states I only go locations on an approved community pass. Those changes have been authorized by staff. On 7/12/26, at approximately 6:20 p.m., you were observed by halfway house staff walking out of the front door at Chase Center without permission from staff or parole. Staff further reported you started running once outside the halfway house. Your employer was called and they reported you did not show for your shift on 7/12/26 from 5 to 2 a.m. You're in violation of halfway house agreement, which states I will not leave the physical confines of the halfway house unless authorized by program staff or parole. And the state has filed the following exhibits that are pre-marked for identification as Exhibit A, remains the actual custody. B is parole condition. C is halfway house agreement. D is notice of parole violation. E is notice of parolee rights. F is parole violation report. G is halfway house incident report dated 7/12/26. H, voluntary admission form or positive test results for prohibited substances. I, St. Mary's after visit summary dated 7/15/26. And J is St. Mary's toxology report. Did you receive notice of parole violation report, and those other documents that I marked, and did you review them?
Yes.
Okay. Do you need to continue the hearing to obtain any additional evidence?
No.
We have no witnesses today. So now is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you so choose. I'm just going to swear you in under oath first in the event you would like to speak. So can you just raise your right hand for me, please? You solemnly swear or solemnly affirm, as the case may be, that the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
Okay, so would you like to say anything in regards to those charges that I just read? You put your hand up.
No. I'm guilty of what I did. The reason why I took off is because I knew I used cocaine, so I thought I was gonna go back to jail. So, which I took off, and I knew it was wrong. That a day or two later, I knew I was wrong, so I turned myself the St. Mary's to try to get myself some help. I wasn't taking my medication at the time, so I was making poor judgment of the situations and what I did. So, and it's not no excuse. That's pretty much it. You know, so I turned myself in with good intentions to clear the water, because I don't want to be on the run. I just, you know, I have a job. I was trying to do good, and you know, I struggle with addiction and mental health problems, and I just need help. That's all.
I'm just noting what you're saying.
Yeah, it's no problem. I should have never listened to everybody at the halfway house. Everybody's like, take off, you're going to jail, you're going to jail. So
Yeah, no, what they want to do is get you help. If you're using anything out there, they want to get you help. We're not trying to bring you back. We want you to do treatment.
yeah,
So,
the parole officer told me that. He's like, why'd you take off? And I was like, I thought I was going to jail. So I freaked out.
yeah, no, this way is the only way to come back to jail. Is why what happened. Unfortunately, if you stay and get help and treatment, you just let us know that you need help, and then that's what they're there for. So it's important just to communicate with your parole officer, because they're there to help you. Did you do any substance abuse treatment in the community before? You were only out there 15 days.
Yeah, I went to the clinic, and then I was doing I got a job, and then I started doing IOP for mental health treatment, because like a couple months before that, I tried killing myself.
Was it for dual treatment, or was it just for mental health?
Just for mental health, because I tried killing myself. So I committed suicide in Renaissance East.
Well, when you went to the hospital this time, when you checked yourself in, was that for substance abuse because you had relapse, or?
Yeah, it was for relapse, and I tried taking fentanyl and killing myself. So I don't know. I just struggle with very depression moods. Every time I'm not on my medication, and something happened with my meds, and that's why I do good when I take my meds, and then when I don't have my meds, I end up using, and then I end up crashing real hard. And I'm having problems with the pharmacy not giving me my medications, and the insurance overlap, because they said I was still in jail. I didn't have my meds at the time, so.
Okay.
Yeah. The last time I stopped taking my meds, this is what happened.
Okay, so you know how important it is to stay on them, right?
Yeah.
Okay. I understand you had some issues, but I'm sure that people are looking to help you out with that as soon as possible. And staying close to your supports, which is going to be the people that we're putting you with to help you out, like parole halfway house staff, they're there to make sure you get these things so that these things don't happen. So make sure you stay connected to them, and don't listen to other, offenders that may be in the halfway house. You know, you're better off talking to staff about stuff. So, is there anything else you want to say in regards to those charges?
No, that's pretty much it. I'm guilty of the charges, what I did, and I'm sorry.
So what I'm gonna do next is I am gonna announce my findings in regards to those charges, okay?
Yes.
So regarding that charge one condition, residents, I'm gonna make a no finding of probable cause on that charge. It doesn't meet the elements, due to the fact you were gone only 2 days and were located at the hospital. And there's no evidence you moved to another location. I make a finding of probable cause on charge 2 Lobel drugs based on the evidence and testimony presented in support of the violation, which exhibits B, G, J, and H. And I do make a finding of probable cause on charge 3 condition halfway house placement based on the evidence and testimony presented in support of that violation, which exhibits B, C, G, and H. I do find the act is serious enough to warrant revocation. So DOC did recommend you for diversion from the revocation process for substance abuse programming and treatment. That means if you wish to participate, apply, and I find that you meet the criteria, I can continue your case while you provide an opportunity to participate in the substance abuse programming and treatment in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board would schedule and convene a revocation hearing to determine if you violated conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or if any sanction should be imposed. So the decision to participate in diversion is voluntary. Do you understand the diversion process and do you want to apply for it? So that's the top program.
Yes.
So are you in that now currently?
Yes.
Okay, so I'm going to announce my findings with respect to your eligibility. If I determine you're eligible, I can accept your application and avert you from revocation. So I have reviewed all the relevant information and my finding is as follows. I find that you have no pending misdemeanor or felony charges. I find your discharge date is more than 60 business days from your return to custody. I find there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And then I find there's some evidence due to you going to the hospital for trying to overdose on fentanyl that I qualifies you to participate in the program. So I've determined you are eligible for diversion from substance abuse programming and treatment. Before I accept your application for diversion, I ask you indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
Okay, I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed. It is conditioned upon my successful completion of the top program.
Yes.
I understand that ultimately the DOC will determine whether I have successfully completed the top program.
Yes.
I understand that my participation in this process is completely voluntary.
Yes.
So your application for diversion is granted and you'll be placed in that treatment program, which you're already in, you stated, and you'll be diverted from revocation for no more than 60 business days. So once you complete the programming, I'll be notified and I will reinstate your parole. Do you have any questions?
That's it.
Okay, sir. So I wish you the best of luck. Make sure, just work with staff when you get out, make sure you get everything you need. And if you have any problems, talk to staff and your parole officer so they can get you the treatment you need, okay, before anything else happens out there, all right?
All right, thank you so much.
All right, good luck, sir.
Have a good day.
Have a good day.